I was standing in courtroom 4B of the Norfolk Family Circuit Court at 9:47 in the morning, wearing my dress blues with the Navy Cross pinned exactly 1 3/8 inches above my left breast pocket, when Magistrate Holloway leaned into his microphone and told me to take it off. $41,000. That is what my husband's family had spent on Magistrate Holloway's re-election campaign in the 11 months before that hearing, and I would not find that number until 6 weeks later. But in that moment, all I knew was that a man in a black robe was asking a combat veteran to remove a medal awarded for pulling 3 sailors out of a burning compartment on the USS Cole Memorial deployment, because, in his words, it was prejudicial theater in a custody proceeding. My sister-in-law, Brooke Ashworth Kellerman, sitting in the second row in a cream Chanel jacket that cost more than my monthly BAH, grinned. Not smiled. Grinned, the kind of grin you give when you already know how the story ends. I did not move, I did not argue. I unpinned the medal, set it on the defense table with the quiet precision of someone who has handled far more dangerous things with far steadier hands, and I said, "Yes, Your Honor." 6 minutes later, his face went the color of old paper, because that was exactly when my attorney rose and asked to enter Exhibit 14 into evidence. And Exhibit 14 was the reason none of them were walking out of that building with what they thought they had already won. If you are watching this from a military family, from a base housing cul-de-sac, from a courtroom parking lot with your hands still shaking on the wheel, comment where you're watching from, because you already know what it feels like when the people who are supposed to protect you decide instead to protect the person who's stealing from you. Hit like, subscribe, and stay until the end, because what happened to my husband's family did not stop at that courtroom. It started there. My name is Elena Marchetti, and 18 months before that hearing, I was a forensic accountant for the Naval Criminal Investigative Services Financial Crimes Division. The kind of job nobody at a dinner party wants to hear about twice. Tracing shell companies and laundered defense contracts for a living. Married to a man named Julian Marchetti who told everyone at those same dinner parties that he was a commercial real estate strategist with a portfolio north of 11 figures, which was a lie so large it had its own gravitational pull. The truth, which I did not fully understand until I started pulling threads I should have pulled 2 years earlier, was that Julian had not closed a real deal since 2019, that the Bayfront Logistics Center he bragged about at his mother's Christmas party was owned 60% by a hedge fund in Charlotte and 40% by me, because I was the one whose credit and whose combat pay had qualified us for the loan. 3 loops were already spinning by the time that gavel came down in courtroom 4B, and I want you to hold on to all 3, because I am going to close them one at a time, and not one of them closes the way you think it will. The first loop was financial. 11 days before the custody hearing, I found a wire transfer on a joint brokerage statement, $48,000, routed to an LLC called Kellerman Family Holdings that I had never heard of and never authorized. Dated the same week Julian filed for sole custody of our 6-year-old daughter, Marisol. The second loop was personal, and it was worse. It was a hotel receipt from the Cavalier Hotel on the Virginia Beach oceanfront, room 412, charged to a card ending in 7734, that was not mine and was not registered under Julian's legal name either. Dated a Tuesday afternoon, when Julian had told me he was in Richmond meeting a title company. The third loop was the one nobody in that family saw coming, because they had never once, in 6 years of marriage, considered the possibility that the quiet Navy officer who kept her mouth shut at Thanksgiving and let Vivian Marchetti correct her pronunciation of Bordeaux in front of the whole table was capable of building a case file the way I build case files for a living. They mistook my silence for weakness. It was reconnaissance. I met Julian Marchetti in 2018 at a Navy League fundraiser in Alexandria, back when I still believed that a man who dressed that well and spoke that fluently about cap rates and cash-on-cash returns must actually understand the numbers he was reciting. He was 34 then, 6 years older than me, with a jaw that looked sculpted for a menswear catalog and a laugh that filled a room before you even heard the joke. His family owned 3 car dealerships across the Tidewater area under the Marchetti Auto Group name, a business his father, Anthony Marchetti Sr., had built from a single used lot on Military Highway into something the local business journal called a Hampton Roads institution. What the business journal never printed was that Anthony Sr. had died in 2015 with the dealership's mortgage to the ceiling against 3 different regional banks, that his widow Vivian had spent the following 4 years living off a life insurance payout and a line of credit she quietly refinanced twice, and that the family fortune everyone in that family referenced at every holiday dinner was, by the time I married into it in 2019, a story they told each other so often it had calcified into fact. I did not know any of that when I said yes to Julian on a pier in Cape Charles with the sun going down behind him, like something out of a movie I should have been more suspicious of. I found out slowly, the way you find out your house has termites, one soft board at a time. The wedding itself should have told me something. Vivian insisted on a guest list of 230 people at a venue on the James River that ran $41,000 for the reception alone, and when the final invoice came due 9 days before the ceremony, it was my combat deployment bonus from my last rotation, $19,400, that quietly covered the gap between what Julian's family had pledged and what they actually paid. A gap Vivian described at the time as, "Just a small cash flow hiccup, dear, you understand business." I understood business. I understood it better than any of them ever gave me credit for, and that was precisely the mistake they kept making for the next 6 years. They assumed that because I wore my hair in a regulation bun and answered yes ma'am and no ma'am at every family function, I was some quiet military wife who counted grocery coupons and deferred to whoever spoke loudest at the table. What I actually did, 5 days a week, in a windowless office on Naval Station Norfolk, was reconstruct the financial lives of people who thought they were smarter than the government. I had helped put away a defense subcontractor who thought a Cayman Islands shell company would hide $11 million in kickbacks. I had unwound a procurement fraud ring that moved money through 4 different shipping manifests before a single federal agent even had a name to attach to it. I did not marry into that family blind. I married in believing love could coexist with financial silence, and it took me nearly 6 years to understand those two things cannot share a house indefinitely, especially not a house where everyone else already knew the truth and had simply decided I was the one person who didn't need to. Marisol was born in March of 2020, 7 weeks premature, 4 pounds 2 ounces, and she spent 11 days in the NICU at Centara Norfolk General, while Julian's mother sent flowers to the hospital gift shop instead of coming in person, because, as she told a mutual friend, "Hospitals give me such anxiety." I remember standing over that isolette at 3 in the morning, watching a monitor count my daughter's heartbeat in green numbers, and thinking that, whatever else happened in my marriage, I would build a wall around that child so high that nothing in the Marchetti family's carelessness could ever reach her. I did not know yet that the wall I needed to build would eventually have to keep her own father on the outside of it too. Julian was, in those early years, a present enough father in the ways that photographed well: birthday parties with a rented bounce house, a trip to Busch Gardens with a professional photographer trailing them for an Instagram reel, a custom-built playhouse in the backyard that Vivian bragged about at every family gathering as though she had built it with her own hands rather than paid a contractor $11,000 for it. A contractor who, I would later discover, had actually been paid from an account with my name on it. The performance of fatherhood, the performance of wealth, the performance of a marriage. I began to understand, somewhere around Marisol's 3rd birthday, that performance was the family business now, more than cars had ever been, and I had been cast, without ever auditioning, as the wife who made the performance look financially credible. The Marchetti Auto Group filed for a debt restructuring in early 2022, a fact that never appeared in any conversation at any Sunday dinner, a fact I only discovered because a compliance colleague at NCIS mentioned, in passing, over coffee, that a Marchetti-affiliated entity had shown up on a routine UCC lien search tied to a fraud case her unit was reviewing for an unrelated dealership group in Chesapeake. I remember the exact moment the coffee went cold in my hand. I did not say anything to Julian that night. I did not say anything the next week either. I went home, and I did what I had been trained to do for 6 years in a windowless office. I started pulling threads quietly, one at a time, from the outside in, the way you approach any subject who might notice if you move too fast. To understand what happened next, you need to understand the 4 people who orbited Julian, because each of them played their part with a consistency that, looking back, almost impresses me. There was Vivian Marchetti, 61 years old, matriarch of the family, a woman whose defining trait was an entitlement so total she seemed to genuinely believe the world owed her its best table at every restaurant, its front row parking at every event, and its silence about the fact that she had not personally paid for a meal outside her own kitchen in nearly a decade. There was Chase Marchetti, Julian's younger brother, 29, nominally the operations manager of the Chesapeake dealership location, a job he treated the way most people treat a gym membership they feel guilty about not using, arriving most days around 11 and leaving by 3, a man whose defining trait was a laziness so complete that even his excuses had a lazy quality to them, half-formed and rarely bothered to be checked for consistency. There was Brooke Ashworth Kellerman, Julian's older sister, 36, married into old Tidewater money through her husband Preston Kellerman, a defense litigation attorney at a firm called Ashworth Kellerman Pruitt. And Brooke's defining trait was a kind of opportunism, dressed up as sisterly concern, the sort of woman who could smell a weakness in a family gathering the way other people smell rain coming. And there was Tara Voss, 28, who I did not know by name for most of my marriage, but who I would come to know intimately through bank records and hotel logs and, eventually, through a face-to-face conversation I did not expect to have and will tell you about when we get there, a woman whose defining trait, as best I could reconstruct it, was a pure and uncomplicated appetite for status she had not earned and did not particularly care how she got. Vivian's entitlement showed up first at the smallest scale. The kind of thing you write off individually and only recognize as a pattern once you have logged enough instances. At Marisol's 4th birthday party, Vivian arrived 40 minutes late, walked past the gift table where every other guest had left a wrapped present, and handed Marisol an envelope containing a handwritten IOU for a special Nana shopping day, an IOU that, 11 months later, had still not been redeemed. At my own promotion ceremony in the fall of 2023, when I made lieutenant commander, Vivian spent the reception afterward loudly comparing the caterer's shrimp cocktail unfavorably to the one at Brooke's engagement party, within earshot of my commanding officer, and when I gently mentioned afterward that the comment had been embarrassing, Vivian's response was, verbatim, "Elena, sweetheart, someone has to keep standards up in this family, and it clearly isn't going to be the Navy." I wrote that one down that night in a private journal I had started keeping, not yet for any legal purpose, just because I had begun to suspect I would need a record of what normal looked like in that house, in case I ever needed to prove to myself later that I had not imagined it. Chase's laziness manifested as a kind of chronic financial hemorrhage that the rest of the family simply absorbed without comment. He had been fired from 2 prior jobs, at a boat dealership in Virginia Beach and a marketing firm in Richmond. Both terminations he described at family dinners as just not the right culture fit, and both of which I later confirmed, through public unemployment insurance filings I had legitimate professional access to, had actually been terminations for cause. At the Chesapeake dealership, service records I would eventually subpoena showed Chase clocking 18-hour work weeks while drawing a salary of $81,000 a year, a salary funded, I would discover, in part by a line of credit that had my name on the personal guarantee, a document I did not remember signing until I found it, dated 11 months into my marriage, in a stack of papers Julian had told me was just standard refinancing paperwork. Don't worry about the details. You have enough on your plate with work. Brooke's opportunism was the most dangerous of the 3, because Brooke was smart, genuinely smart, a magna cum laude graduate of William and Mary who had chosen, deliberately, to marry a man with institutional power rather than build her own, and who used her husband's position at Ashworth Kellerman Pruitt the way other people use a credit card, freely and with the confidence that someone else would eventually cover the balance. Preston Kellerman's firm did not typically handle family law, but Preston had a partner 2 doors down, a man named Douglas Ferris, who did, and it was Douglas Ferris who would, 11 months into my custody battle, sit across the table from Julian's side and quietly explain that Magistrate Robert Halloway had, in fact, attended the same fraternity at the University of Richmond as Preston Kellerman's father, a fact that meant nothing on paper and everything in practice. Brooke's specific talent was making every act of manipulation sound like concern. "I just worry about Marisol's stability," she told me once, over coffee I had not wanted to have with her, 3 weeks before Julian filed for custody, with your job. The deployments, the unpredictability, family should come first. Don't you think, Elena? I remember smiling and saying that I agreed completely. Family should come first, and not telling her that I had, by that point, already begun quietly documenting exactly which family she meant. It was Tara Voss's shadow that finally moved me from suspicion to investigation, though I did not have her name yet when it started. In February of that final year, I noticed Julian had begun taking calls in the garage with the door down. A small detail, almost nothing, except that Julian hated the cold and had complained about the garage's lack of heating every winter we had lived in that house. I noticed his gym membership, which he had held at the same Gold's Gym in Norfolk for 4 years, had quietly lapsed in October and been replaced by a membership at a boutique studio in Virginia Beach called Tidewater Row and Ride, a studio I confirmed, through a public class schedule posted on their website, ran sessions almost exclusively between 10 and 11 in the morning on Tuesdays and Thursdays, hours that corresponded suspiciously well with the title company meetings in Richmond. Julian had started mentioning that same month. I am a forensic accountant. I do not investigate out of jealousy, and I want to be honest with you about that. Because jealousy would have made me sloppy, and I could not afford to be sloppy. I investigated because the financial pattern and the behavioral pattern had started, for the first time in 6 years, to diverge from each other in a way my training told me never happens by accident. When a person's stated location does not match their spending pattern, when their spending pattern does not match their stated income, something underneath the marriage is lying to you, and I needed to know which part. I started with the joint brokerage account first, because that was the account I had legal and practical access to without needing to explain myself to anyone. In March, I found the $48,000 wire to Kellerman Family Holdings, LLC, an entity registered in Delaware 11 months earlier, with a registered agent address that traced back to a UPS store in Virginia Beach. The kind of shell structure my own unit at NCICE had trained me to recognize within about 4 seconds of looking at the incorporation filing. I pulled the Delaware Division of Corporations record on my lunch break, using a public search terminal at the downtown Norfolk Library, rather than a work computer. Because even then, some instinct told me I needed to keep my professional resources and my personal investigation in 2 separate, defensible lanes. Kellerman Family Holdings, LLC, listed a single registered member, Brooke Ashworth Kellerman. The wire had gone out from our joint account on a Thursday in February, the same week, I would later cross-reference, that Douglas Ferris first opened a file with the notation, Marchetti, Custody Consult, in a billing record I would eventually see during formal discovery, 7 months later, once the divorce filing had made such records legally reachable. I did not confront Julian. This is the part people always ask me about when I tell this story. Why I waited, why I kept smiling at Sunday dinners, why I let Vivian correct my pronunciation of Bordeaux 3 more times before any of it came out into the open. And the answer is simple, and it is the same answer I would give any junior analyst who came to me with a partial case file. You do not confront a subject before you understand the full scope of what you are confronting, because a confrontation is also a warning, and a warning gives a guilty party time to destroy evidence, move money, or build a countervailing story. I had watched Julian's family build countervailing stories my entire marriage. I was not going to hand them the raw material for one more. Through April and into May, I built what I privately called, in the encrypted case file I kept on a personal drive that had never once touched our home network, the Marchetti Ledger. I cross-referenced 6 years of joint tax returns against the Marchetti Auto Group's publicly filed Virginia SCC business registrations. I pulled UCC1 financing statements against all 3 dealership locations and found that the Norfolk location had 2 active liens I had never been told about. One from a regional bank for $810,000, and a second, subordinate lien from a private lender called Colonial Bridge Capital for $340,000, personally guaranteed, according to the filing, by both Anthony Marchetti Jr., Julian's legal name, which I had genuinely forgotten was not simply Julian until I saw it printed on a federal document, and by me, Elena R. Marchetti, on a signature page I had absolutely no memory of executing. I found that signature page eventually, buried in a stack of documents Julian had brought home in August of 2021 during what he called just some refinancing on the Bayfront property. Standard stuff, sign where I flagged it, don't worry, you have enough on your plate. I remember that night with a clarity that still unsettles me. Sitting at our kitchen island with a stack of papers Julian had already flagged with yellow tabs, Marisol asleep upstairs, the television murmuring some home renovation show in the background, and me signing 4 pages in 11 minutes because I trusted the man across the counter from me more than I trusted my own professional instincts. An act of trust that would end up costing me, by the time forensic accountants on my own legal team finished their tally the following year, an exposure of $561,000 in personally guaranteed business debt I had never agreed to knowingly carry. By June, I had enough of the financial picture to understand the shape of what Julian's family had actually built, and it was not the empire they performed at every holiday table. The Marchetti Auto Group was, by any honest accounting, insolvent. The Norfolk location's inventory floor plan financing, the loan dealerships used to keep cars on the lot, had been in technical default twice in 18 months, cured both times by capital infusions that traced back, through 4 transfers I mapped across 3 different banks, to a home equity line of credit against the house Julian and I owned together, a house with my combat pay and my NCIS salary as the qualifying income on the original mortgage application. Chase's salary, Vivian's monthly family allowance of $6,200 that I discovered she had been drawing from the dealership's payroll account since 2020, despite holding no formal position in the company, and even a portion of Brooke and Preston's mortgage on their house in Ghent, which I traced through a personal loan document Julian had co-signed without telling me. All of it, every dollar, ran back through accounts where my name, my income, my creditworthiness, and my combat deployment bonuses had been quietly used as the load-bearing wall holding up a family that told everyone, including me, that they were the ones taking care of us. I want to pause here and tell you about a dinner in June, because it is the dinner where I finally understood exactly how deep the family's willful blindness ran. And it is the dinner Brooke would later claim, under oath, never happened the way I described it. Vivian hosted a Father's Day lunch at her house on Chesapeake Bay. 13 people at a table meant for 10, and over dessert, a lemon tart that Vivian mentioned no fewer than 3 times had come from a bakery in Ghent that the Kellermans introduced us to, Anthony Marchetti Sr.'s old business partner, a man named Ray Delgado who had stayed close to the family after Anthony Sr.'s death. Asked Julian casually how the Bayfront refinance had gone through, since Ray had heard from someone at the bank that the deal had gotten interesting. Julian laughed it off, said something about paperwork always being more dramatic than the actual numbers, and changed the subject to a fishing trip he was planning with Chase. Nobody at that table pressed further. Nobody at that table, except possibly Ray, who caught my eye for half a second longer than was comfortable, seemed to register that "gotten interesting" was doing an enormous amount of work in that sentence. I smiled. I passed the lemon tart. I said it looked delicious. And I went home that night and opened a new folder in my case file labeled Ray Delgado, Possible Witness, because a decorated Navy officer trained in pattern recognition does not let a sentence like "gotten interesting" pass without logging it. The custody filing came in July, and it came with a viciousness that, even having built an entire financial case against this family, genuinely surprised me. Julian's petition, drafted by Douglas Ferris and filed in Norfolk Circuit Court, alleged that my military service obligations created chronic instability inappropriate for a child of Marisol's age, cited 2 deployments in the prior 4 years, 1 to the 5th Fleet Area of Operations for 91 days, and 1 shorter training rotation to Rota, Spain, as evidence of a pattern of prioritizing career advancement over parental presence, and requested sole physical custody with supervised visitation for me, pending a psychological evaluation Ferris framed, in the filing's language, as necessary to assess the emotional impact of repeated separations on the minor child. I read that filing standing in the kitchen of the house I had qualified us to buy, holding a document that used my service to my country as a weapon against my right to raise my own daughter, and I felt something in me go very quiet and very still, the same stillness I remember feeling the first time I processed a body recovery report as a junior officer. A stillness that is not the absence of feeling, but the deliberate, disciplined postponement of it until the feeling can be useful instead of destructive. That night, I called my father. My father, Rear Admiral, retired, Marcus Reyes, had spent 31 years in the Navy before retiring in 2019, the last 6 of them as a Judge Advocate General Officer specializing in military family law. And I want to be clear that I did not call him because I needed a lawyer. I called him because I needed my father. And it happened that my father was also, functionally, one of the most dangerous family law strategists in the Commonwealth of Virginia, a fact Julian's family would not fully appreciate until it was far too late to matter. "Send me everything," he said, after I had gotten about 4 sentences into explaining the filing, his voice carrying the exact flat calm I remembered from every crisis of my childhood, the tone that meant he had already stopped being surprised and started being useful. Every document, every bank record, every text message. "Tonight, if you can." I sent him the case file at 11:40 that night. He called back at 6:15 the next morning, before I had even had coffee, and the first thing he said was, "Elena, this isn't a custody case anymore. This is a financial fraud case wearing a custody case's clothes, and we are going to try it as both." My father brought in a colleague of his, a woman named Priya Anand, who had left active duty JAG work 4 years earlier and now ran a small, ferociously effective firm in Virginia Beach, specializing exactly in the intersection of military family law and financial fraud, the kind of niche practice that exists because the world occasionally produces someone diabolical enough to need it. Priya's retainer was $18,000, an amount I paid from savings I had built quietly and separately for exactly this kind of emergency. a habit my own mother had drilled into me growing up. The daughter of an Air Force sergeant who had watched her own mother get left with nothing after a bad divorce in the 1980s. Every woman needs an account no one else has the password to, my mother used to say, and I had listened, and in July of that year I finally understood exactly why. Priya's strategy, laid out across a legal pad on her office conference table on a Tuesday morning, I remember specifically because it was raining hard enough that the windows rattled, was built on a principle she stated plainly. They think this is a story about a mother who's never home. We are going to make it a story about a family who has been laundering their financial collapse through her paycheck for 6 years, and we are going to make Magistrate Holloway choose, in open court, whether he wants to be the judge who protected a decorated combat veteran and her child, or the judge who protected a man who used his wife's Navy Cross deployment bonus to cover a floor plan default. Priya had already pulled Magistrate Holloway's campaign finance disclosures, publicly available through the Virginia Department of Elections, and found the $41,000 figure in donations traceable across 3 different LLCs back to Preston Kellerman, his father, and 2 partners at Ashworth Kellerman Pruitt. This isn't illegal, Priya told me, tapping the printout. Campaign donations from lawyers to judges happen constantly and mostly legally, but it is exactly the kind of thing that, laid out in the right order in front of the right oversight body, makes a sitting magistrate extremely motivated to appear scrupulously, publicly fair in the case currently in front of him. We are not going to accuse him of anything. We are simply going to make sure he knows that we know, and that we are the kind of people who document things. Through August, while the custody case moved through its early procedural stages, I kept working the financial thread with an intensity that, looking back, probably should have worried the people who loved me more than it did. I obtained, through Priya's formal discovery requests, 6 years of Marchetti Auto Group payroll records, and cross-referenced every disbursement against actual documented work product, a process that took me 11 consecutive weekends and that I did largely at my kitchen table after Marisol went to bed. A glass of water instead of the wine I might have wanted, because I needed my hands steady and my eyes sharp for spreadsheet work that would, eventually, matter more than almost anything else I had ever built in my professional life. I found that Chase Marchetti had been paid, over 4 years, a cumulative $311,000 against a job the dealership's own internal time clock software. Software I obtained access to legally, through discovery, once Priya successfully argued that the dealership's finances were directly relevant to the custody petition's central claim of family financial stability, logged him working an average of 14 hours a week. I found that Vivian's family allowance had, over the same period, totaled $298,000, paid from a payroll line item that listed her, absurdly, as executive consultant, a title with no corresponding job description, no corresponding work product, and no corresponding tax withholding structure that would survive even a cursory IRS review, a fact I flagged, quietly, in a footnote to Priya, understanding even then that this case might eventually widen beyond family court, into rooms with federal seals on the door. The interaction that crystallized Vivian's role for me happened at the end of August, at Marisol's kindergarten orientation, a small, ordinary event that Vivian insisted on attending, despite Julian and me being separated at that point, and despite Vivian never once, in 6 years, having attended a single school function for Marisol before. She arrived 20 minutes late in a cream linen dress and made a point of sitting directly across from me at the parent circle activity, smiling the entire time in a way that had nothing warm in it, and afterward, in the parking lot, she caught my arm and said, low enough that no one else could hear, "You know, Elena, it would be so much easier for everyone, especially for Marisol, if you just let this go. Julian's a good father. This family has given you everything. I would hate for things to get ugly." I remember looking down at her hand on my arm, at the pale pink manicure, at a woman who had drawn nearly $300,000 from my daughter's college fund's indirect financial ecosystem for a job title that did not correspond to a single cent email, and I said, very calmly, "Vivian, I think things already are ugly." "I just haven't shown anyone yet," she laughed, a light, dismissive laugh, the laugh of a woman who genuinely believed, right up until the moment it stopped being true, that she was untouchable. Chase's moment came in September, at the dealership itself, where I drove one Wednesday afternoon under the pretense of dropping off a set of spare keys Julian had left at the house, though the actual purpose was reconnaissance, the kind you do in person because certain things, body language, the state of a service bay, who is actually present at a workplace at 2 in the afternoon on a weekday, never show up in a document. I found Chase in the customer lounge, feet up on a coffee table, watching a fantasy football live stream on his phone, with the volume loud enough that two customers waiting for oil changes exchanged a look with each other. He did not stand up when I came in. "Elena!" "Hey, Julian's not here, if that's what you're—" "I know he's not here," I said. "I came to see the dealership." Chase laughed, the kind of laugh people use when they have not thought through what they are agreeing to. "Not much to see. It runs itself, mostly." I looked around the service bay through the lounge window. At 4 bays, only one occupied. At a sales floor with 2 salespeople standing near the door with nothing to do. At an operation that, according to the county's own commercial vehicle inventory tax filings I had already pulled, had moved 40% fewer units in the trailing 12 months than the year before. And I said, "It certainly seems to." Chase didn't catch it. He never did. That was, I think, the truest thing about Chase. Not that he was cruel, the way Vivian could be cruel in her entitlement, or calculating, the way Brooke was calculating in her opportunism, but that he had simply never once, in 29 years, needed to notice anything, because there had always been someone else's money absorbing the consequences of his not noticing. Brooke's second moment, the one that finally confirmed for me exactly how far she had gone, came in early October, 3 weeks before the trial date, when she requested a meeting she framed as just us, sister to sister, no lawyers, at a coffee shop in Ghent near her house. I went, with a small recorder in my coat pocket that Priya had cleared as legal under Virginia's one-party consent statute, a fact I had checked twice before that meeting because I understood exactly how much would depend, eventually, on doing every single thing correctly. Brooke ordered a oat milk latte and told me, over the first 4 minutes, how much she loved me, how much this whole situation was hurting the family, how she just wanted what was best for Marisol. And then, in the 5th minute, the actual purpose of the meeting arrived. "Douglas thinks," she said, stirring her latte with a wooden stick, not looking at me, "that if you dropped the financial discovery requests, focused just on custody terms, this could resolve so much faster. Nobody wants this to get complicated, Elena. Julian would agree to 50-50 custody right now if you just let the business stuff go." "It's not really relevant to whether you're a good mother, is it?" I asked her gently. Why Douglas Ferris, who was not technically representing Julian in the custody matter, was advising on discovery strategy at all. Brooke's face did something small and involuntary, a flicker she covered fast, and she said, "He's just a family friend who happens to know the law, that's all." I did not push further. I thanked her for the coffee, told her I would think about it, and drove straight to Priya's office, where we listened to the recording twice, and Priya said, with something close to delight in her voice, she just admitted, on tape, that Ferris is coordinating custody strategy for a case he isn't formally on. "That's not just useful, Elena. That's a professional conduct problem for Ferris, and it's a bar complaint waiting to be filed the moment we need leverage." Tara Voss. I finally identified by name in the 2nd week of October, through a method so unglamorous it almost embarrasses me to describe. I cross-referenced the Tidewater Row and Ride class schedule against a public Instagram account with location tags, an account belonging to a fitness instructor named Tara Voss who had, 11 months earlier, started posting photos from a downtown Norfolk restaurant called Saltwater, tagged, in 6 separate posts across 4 months, with a man whose face was always cropped just out of frame except in one photo. A poorly lit shot from a rooftop bar in July, where Julian's jaw, unmistakably his jaw, the same jaw I had once found so compelling at a Navy League fundraiser, was visible at the edge of the frame, his arm around Tara's shoulder, a cocktail in his other hand that, based on the restaurant's own posted menu, cost $19 and was called, with a lack of self-awareness I still find almost funny, the Second Chance Sazerac. I did not confront Julian with the photo. I sent it to Priya, who filed it, dated, and archived with a forensic timestamp service, into what was becoming, by that point, an extraordinarily thick case file, and I closed my laptop, and I sat in my kitchen for a long time in the dark, not crying, because I had promised myself I would not do most of my crying until this was over, but feeling, for the first time since July, genuinely, completely furious, not at Julian's family, whose greed I had already priced into my expectations, but at Julian himself, the man I had built an actual life with, who had let a woman who taught spin classes get closer to the truth of who he was than I ever had. By the end of October I had, spread across 3 encrypted folders and 1 physical binder, Priya kept in a locked file cabinet at her office, a case that had grown far beyond anything either of us had initially imagined. There was the financial fraud thread, the personal guarantees I had unknowingly signed, the payroll disbursements to Vivian and Chase that did not correspond to any documented labor, the Colonial Bridge Capital lien, the Kellerman Family Holdings wire, all of it converging on a picture of a family business that had been technically insolvent since at least 2022 and had been propped up, without my informed consent, by my income, my creditworthiness, and my combat deployment bonuses. There was the personal betrayal thread, Tara Voss, the Cavalier Hotel receipt, the second chance Sazerac, a paper trail of small, specific, undeniable facts that no amount of Marchetti family charm would be able to talk its way around in front of a judge who had, by that point, been made uncomfortably aware that people were watching how he handled this case. And there was the third thread, the one I had not fully articulated even to myself until Priya said it out loud in a strategy session in early November. Elena, you're not just building a defense. You're building a complete picture of a family that has spent 6 years mistaking your patience for permission. When this goes to trial, we're not going to ask the court to punish them. We're going to let the truth punish them, in front of every single person who ever underestimated you. I want to tell you something honest about that period, something that does not make it into most stories like this one. I was not sleeping well. I was not eating well. Marisol asked me one night in November while I was tucking her into bed why I looked tired all the time, and I told her that Mommy was working on something important, something that would make things better for both of us, and she said, with the total, uncomplicated faith of a 6-year-old, "Okay, I know you can fix it. You always fix things." I did not tell her that some nights I genuinely did not know if I could. I did not tell her that building an airtight case against your own husband's entire family, while co-parenting a kindergartner through a custody dispute, while continuing to show up every day at Netsius and do a full-time forensic accounting job with the same rigor I always had, while your mother-in-law tells your neighbors you're not quite yourself lately, must be the deployments catching up with her, is one of the loneliest kinds of hard I have ever done. Harder in some ways than anything I carried during either deployment, because at least on deployment everyone around me understood exactly what we were fighting and why. If you've ever had to build a case, quietly, alone, against people who were supposed to be your family, while smiling through every holiday dinner in the meantime, tell me in the comments how long you had to hold it together before anyone else knew what you were carrying, because I think more people are living inside that particular kind of silence than any of us realize, and this channel exists, in part, so that none of us have to carry it feeling like we're the only ones. If this story is doing anything for you right now, hit subscribe before we get to the part where all of it comes due at once, because what happens next is the part I still think about most. The confrontation with Julian happened on its own, without my planning it, on a Sunday evening in mid-November, 3 weeks before the trial date, and it happened because Julian, for all his family's careful choreography, was never actually as disciplined as the rest of them. He came to pick up Marisol for his scheduled visitation, and while she gathered her backpack, he lingered in the doorway of the house we had, by court order, agreed I would keep possession of pending the final decree, and he said, in a tone that tried very hard to sound casual and did not succeed, "Priya's been asking for a lot of financial records lately. Seems like overkill for a custody case, don't you think?" I looked at him, at the man whose jaw I had once found so compelling, and I said, "Julian, I know about Kellerman Family Holdings. I know about the Colonial Bridge lien. I know about Chase's payroll and Vivian's consulting fee. And I know about Tara." I watched something happen in his face that I had genuinely never seen before in 6 years of marriage. A kind of structural collapse. The specific look of a man who has spent so long believing his own performance that he forgot, somewhere along the way, that performances end. "Elena," he started, and I held up a hand because I did not need to hear whatever sentence was forming behind that particular expression. "You have 3 weeks," I said, "to decide whether you want to walk into that courtroom as a man who made some mistakes and is trying to do right by his daughter, or as a man whose entire family gets exposed in open court for exactly what they've built on my back for 6 years. I'm not asking you to choose. I'm telling you the choice exists, because in 3 weeks it won't." He chose badly. Of course he chose badly, because choosing well would have required Julian to act independently of his mother for possibly the first time in his adult life. And Vivian, when Julian told her about the confrontation, apparently responded by escalating rather than retreating. A decision I only learned about later, through Priya, who received a call from Douglas Ferris 2 days after that Sunday evening, informing her that the Marchetti side intended to add a formal request for a psychological fitness evaluation, citing, among other things, my documented pattern of surveillance behavior toward family members. A phrase that would have been almost funny given what that surveillance had actually uncovered if it had not also been a genuine and serious legal threat. The kind of allegation that, taken seriously by the wrong magistrate, could have delayed the case for months and cost me time with Marisol I was not willing to lose. Priya's response to the psychological evaluation threat was, I think, the single sharpest piece of legal strategy I watched anyone execute during that entire year. Rather than fighting the request, she agreed to it immediately, in writing, the same afternoon it was proposed, on the condition that the court order a parallel financial forensic evaluation of the entire Marchetti Auto Group and its principal officers, citing the same statutory standard Ferris had invoked, any factor bearing on the stability of the child's home environment. Magistrate Halloway, who by that point had received, through a channel Priya never fully explained to me and that I never asked her to, a quiet and entirely lawful notification that the Virginia Judicial Inquiry and Review Commission had received an informal inquiry regarding campaign donation disclosures connected to a pending case in his courtroom, granted both requests within 4 days. A speed that Priya described, dryly, as remarkably efficient for a family court docket that had taken 6 weeks to schedule our last motions hearing. The forensic financial evaluation, conducted by an independent court-appointed examiner named Dr. Patricia Nwosu, a certified fraud examiner with 22 years of experience testifying in Virginia circuit courts, took 11 days and produced a report that ran to 63 pages, a document Priya later told me was, in her professional opinion, the single most damaging financial exhibit I have seen introduced in a family court proceeding in 14 years of practice. Dr. Nwosu's report confirmed, independently and with her own methodology, nearly everything I had already found: the personal guarantees, the payroll disbursements without corresponding labor, the Colonial Bridge capital lien, and one thing I had not found, because it lived in records I did not have legal standing to access on my own: a federal excise tax filing discrepancy on the Chesapeake dealership's floor plan inventory, the kind of discrepancy that, Dr. Nwosu noted in a single, carefully worded footnote near the end of her report, may warrant referral to appropriate federal authorities for further review. That single footnote is the reason Special Agent Marcus Whitfield of the IRS Criminal Investigation Division's Norfolk Field Office first appeared on my radar, though I would not meet him in person until January, 2 weeks before trial, when Dr. Nwosu's report, now part of the official court record, crossed his desk through a referral channel that exists precisely for cases like this one, where a family court financial evaluation surfaces evidence of potential federal tax fraud. Agent Whitfield called Priya's office first, then asked to speak with me directly, and I remember sitting across from him at a small conference table in a federal building downtown, a man in his late 40s with the unhurried, methodical manner I recognized instantly from my own training, someone who had clearly spent 2 decades learning that the fastest way through a complex financial fraud case is to never once move faster than the facts allow. Commander Marchetti, he said, I had kept my rank in casual address even mid-divorce. A habit Priya said actually helped in court, reminding everyone in the room exactly who they were dealing with. I want to be straightforward with you. What you and your legal team have already assembled here is more thorough than most of what my own office produces in the early stages of an investigation. I'd like your cooperation formally, and I want you to understand that cooperating does not compromise your custody case. If anything, it strengthens it because it puts an entirely separate, entirely independent federal authority on record confirming the pattern you've already documented. I signed a formal cooperation agreement that afternoon. It was, I think, the first moment in the entire ordeal where I felt something shift from defense into something closer to inevitability. The personal thread, the Loop BC, I had been carrying since October, closed in a way I genuinely had not anticipated. 3 days before trial, when Tara Voss called Priya's office and asked to speak with me. I almost didn't take the call. Priya advised against it, worried it was some kind of coordinated attempt to muddy the waters before trial, but something in me wanted to hear it directly, and so I agreed, on a recorded line, with Priya present. Tara's voice, when it came through, sounded younger than I expected, and considerably less composed than the confident woman in the rooftop bar photograph. I didn't know he was still married when it started, she said, before I had asked her anything. He told me you two were separated. He told me for months. I found out the truth in August, from one of his mother's friends, at an event I wasn't even supposed to be at, and I confronted him, and he cried, actually, and told me he was scared of what his mother would do if he told the truth. That Vivian had basically raised him to believe the family's whole image depended on him staying married to a decorated officer. That divorcing you would look, in his words, like admitting the whole thing was fake. I'm not calling to defend him. I'm calling because I have text messages from Julian, from Vivian directly, and one from Brooke, all of them coaching him on exactly what to say to keep me quiet through the custody trial, and I think you should have them, because I am so tired of being the only person in this who's supposed to feel ashamed. Tara sent the messages that evening, 41 screenshots in total, and among them was a text from Vivian to Julian, dated the previous September, that read, in full, handle the Tara situation quietly before the trial. If Elena finds out and it comes out in court, it will destroy everything we've built. Your father would be so disappointed in how sloppy you've been about this. I read that message 3 times before I fully absorbed what it confirmed. Not just that Julian had been unfaithful, which I already knew, but that Vivian had known for months, had coached her son on managing the affair's exposure rather than telling him to end it or come clean, had treated her son's infidelity not as a moral failure requiring correction, but as a logistics problem requiring better discretion, a distinction that told me more about the entire family's value system than anything else I had uncovered in 5 months of investigation. Priya forwarded the screenshots to Douglas Ferris the next morning with a 2-line email. We are aware of the full scope of the personal conduct issues in this matter. We will not be raising them in the custody hearing unless your client's counsel opens that door first. Please advise your client accordingly. It was, Priya explained to me afterward, not mercy. It was strategy. The kind of restraint that leaves an opponent guessing exactly how much you know and precisely when you intend to use it. A form of pressure that a direct accusation could never achieve. The 3 days before trial passed in the strange, suspended quality of time that I remembered from the hours before a deployment briefing, everything simultaneously too slow and too fast. Every small domestic task, packing Marisol's lunch, ironing my dress blues, confirming with Priya for the 4th time that every exhibit binder was tabbed correctly, carrying a weight that made my hands unsteady in a way 6 years of high-stakes federal casework never had. Priya and I met twice more, once to finalize the exhibit order, and once simply so she could look me directly in the eye and say, Elena, I need you to understand something before we walk into that courtroom. You built this case. I organized it, I filed it, I'll argue it, but every single fact inside it exists, because you refused to stop looking, even when looking cost you sleep, cost you peace, cost you 6 months of pretending everything was fine. At family dinners you had every right to walk out of. Whatever happens tomorrow, that work is already done. Nobody can take that away from you. I did not cry that night either. I had promised myself I would not until it was over. And I kept that promise with the same discipline I had kept every other promise to myself since July. Julian sighed. It turned out later through discovery of Ferris's own trial preparation notes, spent those same 3 days doing something almost the opposite of preparation: damage control. Vivian, according to a deposition transcript from the following spring, had insisted to Douglas Ferris that the custody case remain focused entirely on Elena's deployments and the psychological evaluation, apparently still believing, even after Priya's cooperation counter-request, even after the forensic examiner's report had already become part of the official record, that the financial evidence could somehow be minimized or excluded through procedural objection. Ferris, to his professional credit, apparently tried to warn her. A text message, later produced in an unrelated Virginia State Bar inquiry into Ferris's conduct in the matter, showed him writing to Preston Kellerman 2 days before trial. Your mother-in-law does not seem to understand the scope of what's coming. I've told her 3 times, I don't think she believes me. Preston's reply, according to the same record, was simply, she never believes anyone until it's already happened to her personally. The morning of the trial, I woke at 4:50, though the hearing was not scheduled until 9:30, because my body had apparently decided, independent of my conscious instructions, that this was a day requiring the same pre-dawn readiness I associated with flight quarters and general muster, not a civilian family court proceeding. I made coffee. I did not drink it, mostly, letting it go cold on the counter while I ironed the creases of my dress blues with a precision that had nothing to do with the uniform's actual condition and everything to do with needing my hands occupied. I pinned the Navy Cross exactly 1 3/8 inches above my left breast pocket. The regulation placement, the same placement I had worn to Marisol's christening, to my father's retirement ceremony, to every occasion in my adult life that demanded I show up as fully and undeniably myself as possible. I did not wear it to intimidate anyone. I want to be honest about that, because there is a version of this story where the medal is a prop, a piece of theater deployed for maximum courtroom effect. And that is not quite true. I wore it because it was mine, because I had earned it pulling 3 sailors out of a burning compartment with my own hands, while my lungs filled with smoke I would cough black for 2 weeks afterward, and because on a day when a courtroom was going to spend hours litigating whether I was a fit mother, I intended to walk in as every single thing I actually was, unedited, unminimized, and unashamed. Marisol stayed with my parents that morning, in a house 40 minutes from the courthouse where my father had, the night before, apparently told her, in the careful, age-appropriate way he had once briefed junior officers before difficult operations, that Mommy had some very important work to finish, and that everything was going to be okay, a promise my father made to his 6-year-old granddaughter, with a confidence I hoped, more than I can adequately describe, that the day would fully justify. I drove to the courthouse alone, parked in the same public garage I had parked in for 3 prior procedural hearings, and walked into courtroom 4B at 9:22 in the morning, 8 minutes before the scheduled start, past a hallway where Vivian, Chase, and Brooke were already clustered together near the water fountain. Vivian in a cream jacket that, I noted with the reflexive precision that had become second nature to me by that point, was not the same cream jacket Brooke had worn to the first hearing, but was, unmistakably, from the same designer, the same season, the kind of coordinated wardrobe choice a family makes when appearance still, even now, mattered more to them than substance. Magistrate Holloway called the proceeding to order at 9:31, and for the first 11 minutes, everything unfolded exactly the way Douglas Ferris had scripted it. A recitation of the original custody petition's language about deployments and instability, a formal renewal of the request for supervised visitation, delivered by Ferris in the smooth, unhurried cadence of a man who had given some version of this speech in dozens of courtrooms and had no reason yet to believe this one would go differently. It was at minute 12, after Ferris gestured toward me and made a comment, almost offhand, about theatrical displays of service that have no bearing on parental fitness, that Magistrate Holloway, perhaps trying to appear scrupulously balanced in front of a courtroom he now understood was being watched, looked directly at me and asked me to remove the Navy Cross. I want to tell you what that request actually felt like, standing there, because insulting does not fully cover it. It felt like being told, by an institution I had spent my entire adult life in service to, that the proof of what I had already sacrificed was inconvenient to the story someone else wanted to tell about me. I unpinned it. I set it on the table. I said, "Yes, Your Honor," in the same voice I would have used accepting any other order from any other superior. Because discipline, real discipline, is choosing your battles with total precision, and this was not the battle. Brooke, in the second row, grinned. Priya rose at 9:47. Your Honor, the respondent would like to enter Exhibit 14 into evidence. Exhibit 14 was not, as Ferris apparently expected based on his objection's phrasing, another financial document. It was a sworn declaration from Dr. Patricia Nwosu, submitted alongside her full 63-page forensic report, formally establishing that the Marchetti Auto Group's financial stability, the exact stability Ferris's petition had spent 4 paragraphs praising as evidence of Julian's superior parental fitness, was, in Dr. Nwosu's professional and sworn opinion, a fiction sustained for 4 years by the unknowing personal financial exposure of the very woman the petition sought to strip of custody. Ferris objected on relevance grounds. Magistrate Holloway, after a pause that felt considerably longer than the 4 seconds it actually lasted, overruled the objection, a ruling that Priya later told me she read, correctly, as the exact moment Holloway decided which side of this case he needed to be seen protecting. What followed across the next 2 hours was not, contrary to how these things sometimes get dramatized, a single thunderous cross-examination that broke the case wide open in one blow. It was methodical, almost quiet, the way real forensic testimony almost always is, Priya walking Dr. Nwosu through her findings exhibit by exhibit, the Colonial Bridge Capital lien, the personal guarantee signature page, the payroll disbursements to Vivian and Chase with no corresponding labor, each document entered, each document explained in plain, unembellished language, and I watched, from the respondent's table, as the color slowly, steadily drained from Julian's face, not in one dramatic collapse but in stages, the way a tide goes out. When Priya reached the Kellerman Family Holdings wire and asked Dr. Nwosu to confirm, for the record, the registered member of that LLC, And Dr. Nwosu said, "Clearly, Brooke Ashworth Kellerman," I heard, from the second row, a small, sharp intake of breath that was not Vivian's and was not Julian's. At 11:52, Priya called her next witness, and it was here that the courtroom's temperature genuinely changed, because the witness was not on anyone's expected list. Special Agent Marcus Whitfield of the IRS Criminal Investigation Division called not to testify about an active criminal case, which he could not yet legally discuss in detail, but simply to confirm, under oath, that his office had opened a formal investigation into the Marchetti Auto Group's tax filings following a referral from Dr. Nwosu's court-ordered forensic evaluation, and that Commander Elena Marchetti had provided full, voluntary cooperation with that investigation for the preceding 6 weeks. Ferris rose to object, and Magistrate Holloway, before Ferris had finished his sentence, said, with an unmistakable edge of something that had not been in his voice at 9:31 that morning, "Overruled. I'd like to hear this." I do not think I will ever forget that moment, Holloway's voice shifting from a man performing careful neutrality into a man who had clearly, sometime in the previous 90 minutes, done the math on exactly how badly this was going to look if he did not. It was Ferris himself, in a decision Priya would later describe as the single worst tactical mistake I have ever watched opposing counsel make in real time, who opened the door to the personal betrayal thread. Trying to salvage the narrative of Julian as the more stable, more devoted parent, Ferris attempted, on cross-examination of me, to suggest that my obsessive documentation of the family's finances reflected a broader pattern of controlling, surveillance-oriented behavior that made me, in his words, the less emotionally stable parent in this proceeding, and asked me, directly, whether I had ever surveilled Julian's personal activities in the same way I had surveilled the family's finances. I looked at Priya. Priya gave the smallest possible nod, and I answered, honestly, under oath, that I had become aware, through documentation Julian's own family had provided, of an extramarital relationship between Julian and a woman named Tara Voss, ongoing since at least the previous winter, and that I had chosen not to raise it as a fault-based issue in the custody proceeding because Virginia is a no-fault divorce state, and I did not believe infidelity, on its own, made someone an unfit parent, but that since counsel had opened the question of emotional stability and surveillance, I felt obligated to note, for the record, that I possessed a text message from Vivian Marchetti to her son, dated the previous September, instructing him to handle the Tara situation quietly before this exact trial, so as not to destroy everything we've built. The courtroom, which had been holding a kind of tense procedural quiet for 2.5 hours, made a sound I can only describe as collective, a small, sharp exhale that moved through the gallery like wind through dry grass. Vivian, in the second row, went rigid. Brooke's grin, the one she had been wearing since 9:31 that morning, finally, completely disappeared. Julian, at the petitioner's table, put his head briefly in his hands, a gesture so involuntary and so human that for exactly 1/2 of 1 second, watching it, I felt something that was not quite pity but was adjacent to it. Before I remembered the personal guarantee signature page, and the 11 days Marisol had spent in a NICU isolate, while Vivian sent flowers instead of visiting, and the feeling passed as quickly as it had arrived. Magistrate Holloway called a 15-minute recess, ostensibly to allow both sides to confer with counsel, though Priya told me afterward, with the flat certainty of someone who had watched dozens of judges manage their own exposure in high-profile cases, that Holloway had actually used those 15 minutes to call someone, though she never confirmed exactly who. When the hearing resumed, Ferris did not attempt to continue the cross-examination on the surveillance theory. Instead, in what Priya would later characterize as a lawyer trying to stop the bleeding after the patient has already flatlined, he requested, on Julian's behalf, an immediate off-record settlement conference. Magistrate Holloway granted it, and for 90 minutes, in a small conference room down the hall from courtroom 4B, Priya and Julian's new, hastily consulted independent counsel, because Ferris, it turned out, had already begun quietly extracting himself from formal representation the moment the personal conduct coordination text message entered the record. Understanding immediately the professional exposure it created for him personally as a family friend actively coaching infidelity concealment during active litigation, negotiated terms that would, 3 weeks later, become the final custody and financial settlement order. Julian agreed to full primary physical custody for me, with structured, supervised visitation contingent on completion of a court-monitored financial disclosure process, an unusual condition Priya specifically requested and Holloway specifically granted, designed to ensure Julian could never again quietly leverage family assets against Marisol's stability without judicial visibility. Julian also agreed, separately and outside the custody order itself, to a legal indemnification releasing me from all personal liability on the Colonial Bridge capital lien and every other guarantee I had unknowingly co-signed, an agreement his own new counsel advised him was, given the federal investigation now underway, almost certainly his only realistic path to avoiding a parallel civil fraud suit I was, by that point, fully prepared to file. I walked out of the courthouse at 4:52 that afternoon, 7 hours and 21 minutes after I had unpinned my Navy Cross and set it on a table because a magistrate asked me to, and I stood on the courthouse steps for a moment in the cold November air, and I pinned it back on, slowly, deliberately, in full view of a small cluster of local reporters who had, by that point, caught wind that something unusual had happened inside courtroom 4B that day, though none of them yet had the full story. I did not give a statement. I got in my car, drove 40 minutes to my parents' house, and when Marisol ran to the door and asked, "Did you fix it, Mommy?" I picked her up, held her the way I had held her in that Niku Isolette 4 years earlier, and said, "Yes, baby, I fixed it." The months that followed compressed and expanded in the strange way that recovery always does. Some weeks moving so slowly I could feel every individual hour, others disappearing in a blur of school pickups and case file closures, and, eventually, the quiet, unglamorous work of simply rebuilding an ordinary life. I want to walk you through what happened to each of them individually, because there is something I have learned, watching a family's fictions collapse in real time, that I think matters more than the collapse itself. Consequences, when they finally arrive, rarely land as a single dramatic event. They land as a slow accumulation of smaller losses, the kind that compound quietly, the way debt does, until one day the person carrying them looks up and realizes the life they built no longer exists, and they cannot point to the exact moment it disappeared. Vivian's consequences arrived first, and they arrived through the IRS investigation, which by February had expanded, exactly as Agent Whitfield's early involvement suggested it might, from the excise tax discrepancy on the Chesapeake floor plan into a broader review of the Marchetti Auto Group's payroll practices across all 3 locations. In April, a federal grand jury in the Eastern District of Virginia returned an indictment against Vivian Marchetti on 2 counts of tax fraud related to the executive consultant payments she had drawn for 4 years against a position that produced no verifiable work product, a scheme prosecutors characterized, in their charging documents, as payroll fraud disguised through a fabricated executive title. Vivian's attorney negotiated a plea agreement that fall, avoiding trial in exchange for a sentence of 11 months in a federal minimum security facility in West Virginia, restitution of $298,000, and 5 years of supervised release with mandatory financial monitoring. I did not attend her sentencing hearing, though Ray Delgado, the old family friend who had asked the gotten interesting question at that June lunch, and who had, it turned out, been quietly troubled by what he'd sensed for over a year, told me afterward that Vivian wore, to federal court, a version of the same cream-colored outfit she had worn to my own custody hearing, and that when the judge read the sentence, she did not cry, but her hands, according to Ray, shook the whole time, like she genuinely could not process that any of this was actually happening to her, that the world had finally decided the rules applied to her too. Chase's consequences were smaller in scale, but, in their own way, just as complete a dismantling of the life he had never had to build any real competence to sustain. The Marchetti Auto Group, unable to survive both the federal investigation and the collapse of its financing structure once the Colonial Bridge capital lien came due in full following my indemnification agreement, filed for Chapter 7 liquidation in June, and all 3 dealership locations closed within 4 months, throwing 31 employees, most of them people who had actually done real work for real wages, out of jobs they had held in good faith. Chase, who had never once in his adult life needed to build a resume that reflected actual accomplishment, spent 7 months unemployed before finding work as a floor associate, not a manager, a floor associate, at a competing dealership across town, a position that paid $41,000 a year against the $81,000 he had drawn for barely showing up at his own family's business. A demotion he described, according to a mutual acquaintance who still occasionally updated me on the family's fortunes, as humbling in ways I didn't know I needed, though I confess I am somewhat skeptical of how deep that particular epiphany actually ran. Brooke's consequences were the ones that took longest to fully surface, because Brooke, unlike Vivian and Chase, had built a life with enough independent institutional cover that the family's collapse could not touch her finances directly. But Douglas Ferris's professional conduct, once the "handle the Tara situation" text message and the subsequent revelations about his informal custody strategy coordination, became part of a formal Virginia State Bar disciplinary inquiry that spring, resulted in a public reprimand and an 18-month probationary period on his license. A sanction that devastated Ferris's standing at Ashworth Kellerman Pruitt, and that Preston Kellerman, according to a source inside the firm who spoke to a local business journalist covering the story once it eventually broke publicly that summer, found professionally humiliating in a way that fractured his marriage to Brooke within the year. Brooke and Preston separated in September, and Brooke, who had spent her entire adult life deliberately building status through marriage rather than independent accomplishment, found herself, at 37, facing a divorce of her own, with considerably less institutional protection than she had assumed would always surround her. A fact I did not celebrate, exactly, but did not mourn either. Julian's consequences were, in some ways, the strangest to watch unfold, because Julian, unlike the rest of his family, was never criminally charged with anything. His personal exposure limited largely to the civil indemnification he had already signed and the collapse of a business he had, at least, nominally run rather than merely benefited from. But Julian's real punishment, if you can call it that, was the one nobody in his family had ever prepared him to survive: the total, public dismantling of the identity he had spent his entire adult life performing. Once the dealerships closed and the federal investigation into Vivian became local news, once the Norfolk Business Journal that had once called the Marchetti Auto Group a Hampton Roads institution ran a follow-up story with the far less flattering headline, "Family Dealership Empire Collapses Amid Federal Fraud Probe," Julian found himself, for the first time in 36 years, a man with no family business to inherit, no family fortune to reference at dinner parties, and no wife whose income and creditworthiness could quietly absorb the gap between the life he wanted people to believe he lived and the life he actually could afford. He moved, that winter, into a one-bedroom apartment in Chesapeake, took a job selling commercial insurance, an industry he had genuinely no prior experience in, and according to Marisol, who saw him every other weekend under the court-monitored visitation structure Priya had negotiated, seemed, in her 6-year-old assessment delivered with the blunt honesty only children manage, kind of sad now, but nicer than before, actually. He listens more. I want to be honest about something here, because I think it matters more than the satisfaction of watching consequences land. I did not want Julian destroyed. I wanted him honest, I wanted him accountable, and eventually, slowly, watching him show up for his supervised visitation appointments without excuse. Watching him complete the court-mandated financial disclosure process without the evasions his family had trained into him his entire life. I began to believe that some genuinely humbled version of Julian might, over years, become a father Marisol could actually rely on, separate from the performance his family had required of him for so long. I do not know if that will fully happen. I know that as of the spring after the trial, he had gone 11 consecutive months without missing a single scheduled visitation, a record that would have seemed unremarkable in almost any other father but that, given his history, represented, in Priya's clinical assessment, actual behavioral change, not just performance for the court, and I have chosen, cautiously, to let that possibility exist rather than closing the door on it entirely, because Marisol deserves a father who is trying, even imperfectly, more than she deserves my satisfaction in having been right about all of them from the beginning. Tara Voss, the one person in this entire story who had genuinely been deceived rather than complicit, moved to Charleston that spring, a fresh start she told me about in a final, brief phone call before she left, thanking me for not treating her as an enemy despite everything, and telling me that the experience had taught her something she said she wished she'd learned earlier in life, that a family's performance of stability is not the same thing as actual stability, and that she intended, going forward, to look considerably harder at the difference before she let herself fall for either version again. I never spoke with her after that call, though I heard, secondhand, the following year, that she had started her own small fitness studio in Charleston and seemed, by every account, to be building something genuinely her own for the first time. As for me, the year that followed the trial was the year I finally stopped performing gratitude for a family that had spent 6 years quietly extracting value from my labor, my income, and my service, and started building, deliberately and without apology, a life that reflected what I had actually earned. In March, 8 months after the trial, I was selected for promotion to full commander. a selection board result that felt, this time, entirely uncomplicated by anyone else's borrowed credit. And my father pinned my new rank insignia at a ceremony where Marisol, 7 years old by then, stood in the front row in a small navy blue dress, holding my restored Navy Cross in a velvet box because I had asked her to be the one who handed it back to me, once the ceremony's formal portion concluded. A small ritual that meant more to me than almost anything else that day. I left NISTIS the following year for a position with the Department of the Treasury's Financial Crimes Enforcement Network. Work that let me apply everything 6 years of marriage into that family had inadvertently trained me to recognize, on a scale that mattered to more families than just my own, tracing exactly the kind of shell company and payroll fraud structures that had once nearly cost me my daughter and my financial security, except now doing it as my actual job, with actual federal authority, instead of alone at a kitchen table at midnight with a glass of water instead of the wine I wanted. I think often about the specific moment the whole architecture of that family's deception became visible to me. Not the courtroom, not even the kitchen island where I found the signature page, but a much smaller moment, back in March of the investigation year, before any of it had gone to trial. When I sat in my car outside the Chesapeake dealership after that visit with Chase, watching two salespeople stand near the door with nothing to do, and I understood, with a clarity that felt almost physical, that every single person in that family had built their entire self-conception on a story that required someone else, always someone else, to quietly pay the bill. Vivian required Julian. Julian required me. Chase required the payroll department. Brooke required Preston's institutional standing. And none of them, not once in 6 years, had ever asked themselves what would happen if the person paying the bill finally stopped believing the story was worth the price. I think that is the actual lesson underneath this entire year of my life. More than the courtroom victory, more than the federal indictments, more than watching Vivian's hands shake at her sentencing. Entitlement, real entitlement, the kind that calcifies over decades into something a family mistakes for identity, is never actually about money. It is about a fundamental, almost childlike belief that someone else's labor, someone else's sacrifice, someone else's silence, belongs to you by default, simply because you have never once been required to notice it belonged to someone else first. Marisol turned 7 that March, and I threw her a birthday party in the backyard of the house I had. By then, fully refinanced under my own name alone, a modest gathering, 11 kids from her new second-grade class, a cake I baked myself instead of ordering from the bakery in Ghent that Vivian used to mention at every gathering, and watching her run across that yard in a cape she had insisted on wearing all day, telling every single guest that her mommy was a secret spy who catches bad guys with numbers, I understood that whatever else that year had cost me, it had also taught my daughter something I am not sure she could have learned any other way. That the people who love you the most are not always the loudest people in the room. That quiet, careful work often accomplishes more than performance ever will. And that a woman does not need anyone's permission, least of all a courtroom's, to be exactly as strong as she actually is. I still keep the private journal I started that summer, the one where I first wrote down Vivian's shrimp cocktail comment. And I have added to it steadily in the 2 years since, not out of any lingering bitterness, but because I think there is real value in keeping an honest record of what you survived, especially the parts that seem too small to matter in the moment. I reread it sometimes, usually on the anniversary of the trial, and I am struck, every time, by how many of the entries from that first year read like a woman convincing herself, sentence by sentence, that what she was seeing was real, that the small dismissals and the quiet financial extractions and the family's practiced blindness toward its own dishonesty were not, in fact, imagined slights, but an accumulating, documentable pattern. I think that is the thing I most want anyone watching this to take away, more than the satisfaction of watching Vivian's cream jacket and Brooke's grin finally mean nothing in a federal courtroom. Trust your own pattern recognition. If something in your life feels financially or emotionally inconsistent with the story you are being told about it, you are very likely not imagining it, and the discipline to document quietly, patiently, without tipping your hand before you are ready, is very often the only real power available to someone who has been systematically underestimated by the people who were supposed to protect her. Ray Delgado and I still have coffee occasionally, once every couple of months, at a small diner near the old Norfolk dealership location, now a self-storage facility, an irony neither of us has ever needed to comment on out loud. He told me, at one of those coffees last winter, that Anthony Marchetti Sr., Julian's father, the man who had actually built the original business with his own hands before his death in 2015, had once told Ray, near the end of his life, that he worried the family he was leaving behind didn't understand yet that money you didn't earn honestly always eventually asks for itself back with interest. Ray said Anthony Sr. never got the chance to see how right he turned out to be. I think about that sentence often. I think it is, in its way, the truest epitaph anyone in that family ever earned, and I think it belongs to all of them, not as a condemnation, but as the plainest possible explanation for everything that happened after. There is a piece of that trial day I have not told you yet, because I did not fully understand its significance until months afterward, when Priya finally explained the mechanics of it to me over dinner one evening, both of us slightly giddy on the kind of relief that only arrives long after a crisis has fully resolved. During the 15-minute recess, Magistrate Holloway called after the Vivian text message entered the record. Priya told me he had not simply stepped into his chambers to collect himself. A court clerk, someone Priya had worked with for years and trusted implicitly, mentioned afterward that Holloway had placed a call to the chief judge's office, apparently seeking informal guidance on how to handle a case that had, within the span of a single morning, gone from a routine custody matter into something with visible federal and disciplinary implications for at least 3 licensed attorneys in the room. Whatever guidance he received, Holloway returned to the bench a visibly different judge than the one who had asked me to remove my medal 2 hours earlier. More careful, more deliberate, more obviously conscious that every ruling he made from that point forward would be read, by anyone who eventually looked closely at this case, as a test of exactly how compromised his earlier campaign finance-adjacent conduct had actually made him. I do not know to this day whether Robert Holloway ever faced any formal sanction for the donations Priya had quietly flagged before trial. I know that he did not seek re-election 2 years later, choosing instead, according to a brief item in the same Norfolk Business Journal that had covered the Marchetti collapse, to pursue private mediation work, a career pivot that a great many people in the Tidewater legal community apparently found unsurprising. Dr. Nwosu's testimony, which I only described to you in broad strokes earlier, deserves a fuller account, because it was, in Priya's professional assessment, the single most important 2 hours of the entire proceeding. Dr. Nwosu walked the court through the Marchetti Auto Group's financial statements with the unhurried precision of someone who had clearly done this exact kind of testimony hundreds of times before, using a small laser pointer on a printed exhibit board to trace, line by line, the exact path $48,000 had traveled from our joint brokerage account into Kellerman Family Holdings LLC, and from there into a payment against Brooke and Preston's own mortgage. A transaction Dr. Nwosu characterized, in language precise enough that even Ferris could not meaningfully object to it, as financially indistinguishable from a family loan structured to avoid gift tax reporting requirements, funded entirely by the respondent's separately titled brokerage assets without her documented consent. She then walked through the payroll analysis, cross-referencing Chase's badge swipe records, which the dealership's own security system had logged with a specificity none of them apparently anticipated anyone would ever subpoena, against his salary, arriving at an hourly effective rate, she noted dryly under Priya's questioning, of approximately $111 per hour for work that, on the days actually documented, appears to have consisted primarily of administrative tasks a part-time high school employee could reasonably have completed. Someone in the gallery, I never found out who, laughed audibly at that line, a single sharp bark of a laugh quickly suppressed, and Magistrate Holloway did not even bother to gavel it down. Preston Kellerman was not present at the trial itself, a fact Brooke's own testimony, when Priya briefly called her to the stand regarding the Kellerman Family Holdings LLC filing, tried and failed to explain away as a scheduling conflict with his caseload, though everyone in that courtroom by that point understood the actual reason was that Preston, informed the previous evening by his own law partner that his firm's involvement in coaching custody strategy for a case Ferris was not formally counsel on, had just become a live professional conduct problem, had spent the morning of the trial in an emergency meeting with the firm's managing partners, rather than sitting supportively behind his wife in a courtroom gallery. Brooke's testimony lasted 11 minutes. She answered every question about the LLC in clipped, monosyllabic sentences, a stark and, I imagine, deeply uncomfortable contrast to the warm, concerned sister persona she had performed so fluently at that coffee shop in Ghent 5 weeks earlier, and when Priya asked her, directly, whether she had discussed custody strategy with Douglas Ferris, despite him not being formally retained on the custody matter, Brooke looked for just a moment directly at me, and I watched something pass across her face that I can only describe as the specific, particular humiliation of a genuinely intelligent person finally understanding that her own cleverness had been outmatched by someone she had spent years dismissing as harmlessly quiet. When the settlement conference finally concluded and Priya and I walked back out into the main hallway to collect my things, the scene waiting there was one I have replayed in my mind more times than almost any other moment from that entire year. Not because anything dramatic happened, but because of how quiet it actually was. Vivian sat alone on a bench near the water fountain, no longer surrounded by Brooke or Chase, both of whom had apparently already left the building separately, her cream jacket looking, in that fluorescent hallway light, less like a symbol of effortless wealth and more like exactly what it was: an expensive garment worn by a woman whose entire financial foundation had just been publicly revealed as built on someone else's labor. She looked up at me as I passed, and for a moment I thought she might say something, some final attempt at the guilt-inducing warmth she had deployed so effectively for 6 years. And instead, she simply looked away first, toward the window, toward the parking garage, toward nothing in particular, and I understood, watching her do it, that this was the actual sound of entitlement, finally meeting a consequence it could not talk its way around. Not an argument, not a confrontation, just silence. And a woman who had spent 61 years assuming the world would always eventually agree with her, quietly discovering that it would not this time, not ever again in quite the same way. Julian caught up with me in the parking garage, 3 levels down, moving quickly enough that I heard his footsteps before I saw him, and for a moment, walking alone toward my car in a mostly empty concrete structure, some old, half-buried instinct from my training made my hand move slightly toward the strap of my bag before I recognized his voice calling my name and understood there was nothing here that required that particular kind of readiness. "Elena," he said, stopping a careful distance away, close enough to talk, far enough to signal he understood he had lost any right to close that gap further. "I need you to know I didn't plan any of this. The Tara thing, the money, I didn't sit down one day and decide to build a life on your back. It just kept happening, one small thing at a time, and every time I thought about telling you, my mother would say something about how the family needed this, how you'd understand, how you always understood, and I let that be enough of an excuse for way too long." I looked at him for a long moment, at a man I had once genuinely loved, standing in a parking garage in a suit that no longer fit the story he had spent 6 years telling about himself, and I said, "Julian, I believe you didn't plan it. I think that might actually be the saddest part of all of this. You didn't need a plan, you just needed a family that never once asked you to have one, and a wife patient enough not to notice how long that could go on." I did not wait for him to respond. I got in my car, and I drove to my parents' house, to Marisol, to the rest of my life. The second year after the trial taught me things the first year, consumed as it was with legal proceedings and federal cooperation and the sheer administrative weight of rebuilding a financial life from the ground up, simply did not have room to teach me. The first year was about survival, about documentation, about proving, exhibit by exhibit, that the story I had lived was the story that had actually happened. The second year was about learning what it felt like to build something without anyone else's hidden hand, quietly redirecting a portion of it somewhere I hadn't agreed to. I refinanced the house that spring under my name alone, a process that took 11 weeks and that felt, each time I signed another document, like slowly removing a series of small, invisible weights I had been carrying so long I had stopped noticing their pressure. I opened a 529 college savings account for Marisol that January, funded entirely from my own salary and my treasury positions signing bonus. And I remember sitting at my kitchen table the night I set up the automatic monthly contribution, $500 a month, watching the confirmation screen load, and feeling a kind of clean, uncomplicated satisfaction I had not experienced in years, the satisfaction of building something that belonged, unambiguously, entirely to my own child, with no shell company, no hidden guarantee, no family narrative attached to it that I would someday have to unwind in a forensic report. I started seeing someone that second year too, a Coast Guard officer named Daniel Osei, stationed at Portsmouth, whom I met, appropriately enough, at a joint service financial literacy seminar I had been invited to speak at, a coincidence I still find slightly funny, given everything that led me there. Daniel was patient in a way I had not previously understood I needed, the kind of patient that did not require me to perform recovery on any particular timeline, that let me talk about the trial when I needed to, and did not ask me to relive it when I didn't. And when I finally told him the full story, 6 months into dating, sitting on my back porch on a warm evening while Marisol slept upstairs, his first question, after listening to the entire thing without interrupting once, was simply, "What does Marisol call you now, when she talks about that year?" I told him she called it the year Mommy fixed everything, and Daniel said quietly, "That's a pretty good legacy for a year that hard." And I remember thinking in that moment that it was the first time since the trial that someone had described what I'd done, not as a cautionary tale about a broken marriage, but simply, plainly, as an accomplishment. Marisol's second grade year brought its own small, unexpected reckonings. Her teacher called me in October to mention, gently, that Marisol had described during a classroom family tree project her paternal grandmother as living somewhere far away now doing a timeout, a description that was, structurally, not inaccurate, and that made me laugh out loud alone in my car afterward in a way I had not laughed in longer than I wanted to admit. I did not correct the framing. Children process complicated truths in whatever language keeps them safe, and a very long timeout was, in its own way, exactly what a federal minimum security sentence actually is. Marisol saw Julian every other weekend, consistently, through that entire second year, and slowly, cautiously, I began to notice real changes in him beyond the surface-level humility Priya had first clinically noted. Small things, like him showing up 15 minutes early instead of exactly on time, or once, memorably, calling me directly, not through any formal channel, simply to ask my opinion about which of 2 elementary schools might better suit Marisol's reading level. A conversation that would have been unthinkable from the man who once let his sister coach him on managing an affair's exposure rather than end it. Vivian wrote me a letter from the federal facility in West Virginia that first winter, 4 handwritten pages that I read once, carefully, standing at my kitchen counter, and have not reread since, though I have kept it, filed in the same drawer as my private journal, because I have come to believe that even the documents you do not want to revisit are worth preserving as evidence of exactly who someone was in a specific, unguarded moment. The letter alternated, in a way I found almost clinically interesting given everything I now understood about her, between genuine-sounding remorse. I think about Marisol every single day and I am ashamed of what I cost her, and the same reflexive entitlement that had defined every interaction I'd ever had with her. Though I do think, Elena, if you're honest with yourself, you'll admit the sentence was excessive for what amounted to a family bookkeeping disagreement. I did not write back. Priya, when I mentioned the letter to her, told me that was almost certainly the correct call, both legally, given the ongoing supervised release terms that govern Vivian's contact with anyone connected to the case, and personally, because, in Priya's words, some apologies aren't actually apologies, Elena. They're just the entitlement finding a new, quieter costume to wear. Chase, for his part, seemed to settle, over that second year, into something that was not quite growth but was at least a kind of grudging stability, the floor associate job slowly evolving into something closer to an actual sales position once he apparently discovered, somewhat to his own surprise, according to the mutual acquaintance who still occasionally updated me, that he was reasonably good at actual customer-facing sales work when the paycheck genuinely depended on doing it, an irony I do not think was lost on him, though he never said so directly to anyone who reported back to me. He moved out of the condo his mother's dealership income had once subsidized and into a modest one-bedroom apartment near Military Circle, a downgrade he apparently described to a coworker, without any evident sense of the deeper irony in the phrase, as finally living within my means, which honestly feels kind of freeing. I do not know if Chase will ever fully understand what he cost other people to sustain the version of his life that came before that freedom. I know that the version of his life that came after it seemed, by every second-hand account I received, considerably more honest, if considerably smaller. Brooke's rebuilding took the longest and, I think, cost her the most in ways that had nothing to do with money. Her divorce from Preston finalized that second autumn, and she left the marriage with a settlement that, while not insignificant, required her, for the first time in her adult life, to actually practice the law degree she had earned at William and Mary, rather than simply hold it as a credential, attached to a more powerful husband's institutional standing. She took a position, I eventually learned, at a mid-sized firm in Richmond doing municipal bond work, unglamorous, technical, entirely disconnected from the family law strategy she had once helped orchestrate from the shadows of her husband's partnership. And a colleague of Priya's who occasionally crossed paths with her professionally described Brooke, 2 years out from the trial, as sharper than you'd expect, honestly, once you take away all the performance. Turns out she's actually good at the actual lawyering part, when she has to be the one doing it instead of just directing traffic. I found some genuine, if complicated, satisfaction in that description. The possibility that the most dangerous person in that entire family might, eventually, build something real once the shortcuts were no longer available to her. Though I have never once felt any obligation to root for her recovery the way I have, cautiously, allowed myself to root for Julian's. I get messages, now, on this channel, from women in situations that echo mine in ways that still catch me off guard, sometimes several a week, and I want to share, before I get to the part of this story I still haven't told you, some of the patterns I have come to recognize across all of them, because I think naming a pattern is often the first real step toward escaping it. The pattern almost always starts small. It starts with a single signature on a document you did not fully read because someone you trusted told you not to worry about the details. It starts with a family member's casual comment about your career, your service, your choices, delivered often enough and confidently enough that you begin, slowly, to doubt your own read of the situation rather than theirs. It starts with money moving in directions you cannot immediately explain, amounts small enough individually to dismiss, until one day you add them up and realize the total is not small at all. And it almost always, in my experience and in the experience of nearly every woman who has written to me about her own version of this story, continues far longer than it should, not because the woman living inside it is foolish or naive, but because families that build their identity on entitlement are remarkably professionally good at making their extraction feel like love, at making silence feel like loyalty, at making the person quietly funding their fiction feel as though speaking up would be the actual betrayal. If any part of what I just described sounds even a little familiar to you, I want you to hear this clearly. Documentation is not paranoia. Keeping your own financial account, your own record of conversations, your own quiet, careful case file, is not a betrayal of the people you love. It is the single most protective thing you can do for yourself and for whoever depends on you, and it costs you nothing until the day it becomes the only thing standing between you and losing everything, at which point it becomes the only thing standing between you. I built that case file for months, believing, some days, that I was being unreasonable, that surely a family who smiled at every holiday dinner could not actually be capable of what the numbers were increasingly telling me they were capable of. I was wrong to doubt myself. I was right about the numbers. And I think the single most important thing I can tell any of you watching this, whether you are in a military family navigating a family court system that does not always understand the difference between service and instability, or simply in any relationship where something in the financial picture does not match the story you are being told, is this. Trust the numbers before you trust the performance. Numbers do not perform. Numbers do not grin in a second-row courtroom bench. Numbers, eventually, always tell the truth, whether or not the people standing in front of them are ready to hear it. I think about that courtroom often, still, more than 2 years later, and I think about the specific moment Magistrate Holloway asked me to remove my Navy Cross, because I have come to understand that moment as the exact hinge point of everything that followed, not because the medal itself held some magical power, but because of what my response to that request revealed about the discipline I had spent an entire career building, discipline that family had spent 6 years mistaking for passivity. I did not argue with an unfair request in that moment, because arguing would have cost me nothing except the appearance of composure. And composure, I understood even then, standing there with a cold table under my fingertips, was the only currency in that room I fully controlled. I gave them the medal. I kept everything else. And when I pinned it back on those courthouse steps in front of reporters who did not yet understand what they were looking at, I was not performing defiance for an audience. I was simply putting back on, quite literally, the only accurate account of who I had always actually been underneath every story that family had ever told about me. I have not told you yet about my father's own history with this particular kind of family, and I think it explains something about why he moved as fast and as precisely as he did the moment I called him that July night. My father grew up outside Roanoke, the youngest of 4, in a household where his own older brother, my uncle Teodoro, spent 2 decades quietly siphoning money from their aging parents under the cover of managing the family finances. A pattern my father did not fully uncover until my grandmother's death in 2011, revealed an estate worth a fraction of what it should have been, drained slowly over years through exactly the kind of small, deniable transfers I would later recognize in the Marchetti family's own financial architecture. My father never took Teodoro to court. He told me once, the only time he ever discussed it with me directly, that he had regretted that restraint for the rest of his life, that watching his brother walk away from what amounted to elder financial abuse with nothing more than a strained Thanksgiving relationship had taught him a lesson he apparently waited 30 years to have the opportunity to apply on someone else's behalf. "I wasn't going to let that happen twice in this family," he told me, the morning after I sent him my case file, sitting across from me at his kitchen table with 2 untouched cups of coffee between us. Not to my own daughter, not while I still had the capacity to do something about it. I think that inheritance, if you can call it that, a father's unresolved grief over his own family's quiet theft, transmuted decades later into the ferocity with which he fought for mine, is one of the truest gifts anyone has ever given me, even though I know it cost him something to finally, fully confront it. Priya's own background, which I only learned in full over the many hours we spent together preparing for trial, gave her a similarly personal stake in cases like mine, though she rarely discussed it with clients directly. She had grown up the daughter of an army colonel and had watched, as a teenager, her own mother nearly lose custody of her younger siblings during a contentious divorce. In a hearing where a judge, in the mid-1990s, had made comments about her mother's unstable, frequently absent military spouse status that Priya described to me once as almost word for word what Ferris tried to argue about you, 30 years later, like the entire system just recycles the same lazy assumption about military families generation after generation. Priya had gone to law school specifically to build a practice that could meet that assumption with the kind of documented, methodical, unassailable counter-evidence her own mother had not had access to in 1996. And I think that history is part of why she fought my case with an intensity that went beyond even her considerable professional standards. Why she answered emails at 11 at night and drove, unbilled, to a records office in Chesapeake on a Saturday to personally retrieve a document she was worried a mail request might delay by a critical week. The federal sentencing hearing for Vivian, which I mentioned only briefly earlier, deserves a fuller account, because Ray Delgado's report of it stayed with me in a way that surprised me with its weight. The hearing took place in April, in a federal courtroom considerably more austere than the wood-paneled dignity of Norfolk Circuit Court, a room with government seals and flat fluorescent light, and none of the theatrical gravity Vivian had always seemed to associate with consequence. The prosecutor read into the record a full accounting of the executive consultant scheme, $298,000 over 4 years, and noted, for the sentencing judge's consideration, that Vivian had shown, in the prosecutor's words, a documented pattern of using family financial infrastructure to extract resources from a family member without that member's informed consent, a pattern the government considers an aggravating factor given the victim's status as an active duty service member whose combat deployment income was directly implicated in the underlying fraud. Ray told me the phrase, combat deployment income, visibly affected the judge, whose own son, it turned out, had served 2 tours in Afghanistan. A coincidence the sentencing judge did not mention directly, but that Ray, watching from the gallery, felt certain shaped the 11-month sentence handed down, a sentence at the higher end of what federal guidelines for the charged offense typically recommended. I want to go back for a moment to the deployment itself, the one that earned me the Navy Cross, because I have referenced it several times throughout this story without ever actually telling you what happened, and I think, given everything that medal came to represent in that courtroom, it deserves its own accounting. It was 2016, during a training exercise off the coast of Bahrain, aboard a guided missile destroyer, not combat in the traditional sense the courtroom filing implied when it referenced my deployment instability, but a shipboard fire in an auxiliary machinery space that broke out during a live engineering casualty drill, a fire that, within 4 minutes, had filled the compartment with smoke thick enough that visibility dropped to less than 2 feet. I was 26 years old, a junior lieutenant assigned to the ship's damage control training team, and when the general alarm sounded, I did not think, in any conscious, deliberate way, about heroism or medals or any of the language that would eventually get attached to those 11 minutes. I thought about the 3 sailors I knew were still inside that compartment, based on the muster count our chief had shouted over the noise, and I went in, on my hands and knees below the smoke line, following the bulkhead with one gloved hand while I called out names into a respirator mask that fogged faster than I could clear it. I found Petty Officer Reyes first, unconscious near a valve manifold, and dragged him 11 feet to the escape trunk before going back for the other 2, who I found together, disoriented but conscious, and guided out by voice and by grip, one hand on each of their shoulders, through smoke that had by then gone from gray to a thick, oily black that I still, occasionally, taste in the back of my throat in dreams I have perhaps twice a year, always on the anniversary, always exactly the same. I coughed black for 2 weeks afterward, as I mentioned earlier, and spent 3 days under observation for smoke inhalation before returning to full duty. And when the Navy Cross citation was eventually read at a ceremony on the ship's flight deck 4 months later, I remember standing at attention, feeling almost embarrassed by the language, the conspicuous gallantry, the extraordinary heroism, because in the actual moment, none of it had felt like gallantry. It had felt like the only possible thing to do. The same unremarkable, undeniable clarity I imagine any parent feels running toward a burning building where their child is trapped. A clarity that has nothing to do with courage as an abstract virtue, and everything to do with simply refusing to let 3 names go unanswered on a muster list. I tell you this now because I think it matters, given everything that metal came to represent in a Norfolk courtroom 8 years later, that you understand exactly what Magistrate Halloway asked me to set aside as theatrical, and exactly what I chose in that moment, not to argue about. Because I understood, even standing there with my hand still warm from the pin, that some battles are worth losing quietly, so you can win the ones that actually matter. Petty Officer Reyes, incidentally, the sailor I pulled out first, still sends me a card every December, a tradition that started the year after the fire and has never once lapsed in the 8 years since. And when the story of the custody trial eventually made its way, through channels I never fully traced, into a small regional news segment the following spring, a segment that focused primarily on the Magistrate Halloway campaign finance angle once it became a matter of public record through the Judicial Inquiry and Review Commission's eventual, quietly issued private admonishment, Reyes called me directly, the first time he had ever called rather than written, and said, simply, "Ma'am, for what it's worth, I always knew you were the toughest person on that ship, and I'm not surprised at all that some judge in a courtroom found that out the hard way too." I have kept every one of his cards. I keep them in the same drawer as Vivian's letter and my private journal. An odd little archive of exactly who showed up for me and exactly who did not, across the 2 most defining crises of my adult life. I should tell you too about the promotion ceremony in more detail, because it is the moment that, more than any single legal victory, marked for me the actual end of that chapter of my life and the beginning of whatever came after it. It was held on the flight deck of a ship moored at Naval Station Norfolk. A bright, cold March morning, wind coming off the water sharp enough that the ceremony's program had to be weighted down with small metal clips, and I stood at attention in my dress blues while the presiding officer, a captain I had worked under for 2 years, read the selection board's citation aloud. Language about sustained superior performance, about exceptional judgment under complex and sensitive circumstances. Language that I understood, reading between its careful institutional phrasing, was as close as a formal Navy citation ever gets to acknowledging that the year I had just survived personally had not, in any way, diminished the quality of the work I had continued to produce professionally, that I had, in fact, closed 2 other unrelated fraud cases during that same period, with a thoroughness colleagues later told me they found genuinely remarkable given what they eventually learned I had been managing at home. My father pinned the new rank insignia onto my shoulder boards, his hands steady in a way that surprised me, given how unsteady my own had been through most of that year, and Marisol, 7 years old, stood in the front row in her small navy blue dress, holding the velvet box with my Navy Cross inside it, exactly as we had planned the night before over dinner. And when the formal portion of the ceremony concluded and the small crowd began to applaud, she walked forward, not waiting for anyone's cue, and handed me the box with both hands and a seriousness that made several people in the audience laugh, warmly, and said, loud enough for the first 2 rows to hear clearly, "Here, Mommy, you earned this one too." I pinned it back on myself, this time deliberately, not because anyone had asked me to remove it and I was restoring it, but simply because it belonged there, on a uniform that represented a career I had built entirely on my own competence, standing on a flight deck surrounded by people who had never once needed to be convinced of my worth by anything other than the actual quality of my work. And I remember thinking, in that specific moment, that this, more than the courtroom, more than the federal indictments, more than any single consequence that had landed on any single member of that family, was what winning had actually felt like. Not the collapse of people who had underestimated me, but the quiet, uncomplicated ability to stand fully in my own accomplishments, in front of the people who mattered, without a single voice in the crowd questioning whether I deserved to be there. Daniel was there too, that day, standing near the back with a small bouquet of flowers he later admitted he had bought somewhat nervously, unsure whether flowers were an appropriate gesture for a military promotion ceremony, And when I found him afterward in the small reception that followed, he told me, quietly, that watching Marisol hand me that velvet box had been one of the more genuinely moving things he had witnessed in a long time, and that he hoped, someday, if things between us continued the way they seemed to be going, that he might get to stand a little closer to that front row himself. I did not know, that day, exactly how things between us would eventually go, though I can tell you now, from the distance of 2 more years, that he did, eventually, get considerably closer to that front row, close enough that Marisol now calls him, entirely on her own initiative and with no prompting from me, by a nickname that still makes my chest tighten every time I hear it, though that particular story, I think, belongs to a different video. There is one more scene from that year I have deliberately saved for near the end of this story, because I think it captures something the courtroom victory, satisfying as it was, could never quite fully capture on its own, and it happened at Thanksgiving, the one that fell almost exactly 1 year after the custody trial. The first Thanksgiving of my life as an adult that I spent entirely free of any obligation to perform gratitude at a table I had never actually felt welcome at. I hosted it myself that year, at my own house, the one now refinanced entirely under my own name, with my parents, with Daniel, with Marisol, and, at Marisol's specific and somewhat surprising request, with Julian, who arrived at 2 in the afternoon with a store-bought pie and an expression of genuine, careful gratitude at being included. An expression I had honestly never once seen on his face in 6 years of marriage to his own family's endlessly performed abundance. We did not discuss the trial. We did not discuss Vivian, or Chase, or Brooke, or the federal case, or Colonial Bridge Capital, or any of the architecture that had once quietly governed every interaction in that extended family. We talked about Marisol's second-grade reading level, about a fishing trip Julian was planning, this time genuinely, with a coworker from his new insurance job, about my father's retirement garden, about nothing at all consequential, and I remember standing in my own kitchen that afternoon, checking on a turkey I had brined myself for the first time, listening to the ordinary, unremarkable sound of a family having an unremarkable conversation in the next room, then understanding, with a suddenness that nearly brought tears I had otherwise successfully avoided for over a year, that this specific, quiet, undramatic normalcy was the actual thing I had been fighting for the entire time, more than any exhibit number, more than any federal indictment, more than the specific satisfaction of watching Brooke's grin disappear in a Norfolk courtroom. I had been fighting for a Thanksgiving table where every single person present actually belonged there, honestly, without a single hidden ledger running underneath the conversation. Vivian was, of course, still serving her federal sentence that particular Thanksgiving, a fact none of us mentioned directly at the table, though I noticed my father, at one point, glance briefly toward the empty end of the table where, in the years of my marriage, Vivian had always insisted on sitting, closest to the kitchen so she could, in her words, keep an eye on how things are being prepared. And I wondered, briefly and without any real desire for an answer, what Vivian's own Thanksgiving looked like that year, in a federal facility in West Virginia, whether she understood yet, whether she would ever fully understand. That the empty chair at my table that day was not an absence anyone present particularly grieved, but simply the natural, unremarkable consequence of a woman who had spent decades assuming her seat at every table was permanent, finally discovering that permanence, like everything else in that family's story, had always actually depended on someone else's willingness to keep paying for it. I think about Anthony Marchetti Sr. sometimes too, Julian's father, the man who actually built the original dealership with his own hands, whom I never met, who died 4 years before I married into his family, and I wonder, sometimes, what he would have made of everything that happened to the empire he built. Whether Ray Delgado's account of his late-life worry about money, that always eventually asks for itself back, with interest, reflected a man who had already begun to see, in his final years, exactly the cracks his family would eventually fall through, or whether it was simply the kind of generalized parental anxiety every father who has built something from nothing eventually voices about the children who will inherit it. I will never know for certain. But I keep, in an odd way, a kind of respect for him that I never developed for the rest of his family. A respect rooted in the simple, verifiable fact that whatever else happened after his death, the actual foundation he built, before entitlement and extraction hollowed it out from the inside, had been real, had employed real people, had served real customers honestly for over 3 decades, a foundation his own family, given the chance to either honor or exploit it, chose, almost unanimously, to exploit. I mentioned earlier that I keep a private journal, and I want to share one more entry from it now, not because it advances the plot of this story in any legal or factual sense, but because I think it captures something about the internal cost of what I went through that year that the courtroom exhibits and the federal sentencing outcomes, thorough as they were, could never fully document. I wrote this on a Tuesday night in September, roughly 2 months before the trial, after a particularly exhausting day that had included a full shift at NCSIS, 3 hours of discovery document review with Priya, and a phone call from Vivian in which she casually mentioned, apropos of nothing, that she had run into an old family friend who had asked whatever happened to that nice young man Elena used to date before Julian, a comment so precisely, surgically designed to make me feel replaceable, disposable, easily forgotten within her family's story, that I sat in my car in my own driveway for 11 minutes afterward before I could bring myself to go inside and be present for Marisol's bedtime. The entry reads, in part, I am so tired of being underestimated by people who have never once had to prove anything about themselves beyond simply being born into a name. I am tired of smiling at a table where every single person assumes my silence means I have nothing to say, rather than understanding that I am the only person at that table disciplined enough not to say everything I already know. I keep telling myself the exhaustion is temporary, that it ends the moment I have enough evidence. But some nights, I genuinely do not know if I have the strength left to finish building what I started. I am going to finish it anyway. Marisol deserves a mother who finishes what she starts, even on the nights it costs her almost everything she has left. I include that entry now, at the end of this story, because I think it matters that you understand this was not a triumphant, easy year for me, no matter how satisfying the courtroom outcome eventually looked from the outside. Every single piece of evidence I gathered, every quiet dinner I sat through smiling while documenting, in my head exactly which lie I had just watched someone tell. Every night I stayed up past midnight cross-referencing payroll records instead of sleeping, cost me something real, something that took considerably longer than a single courtroom victory to fully repair. I do not think strength, real strength, looks the way it gets portrayed in most stories like this one, as some unwavering, effortless competence that never once wavers or doubts itself. I think real strength looks like continuing to do the disciplined, unglamorous work of documentation and patience on the nights you are genuinely not sure you have anything left to give it, simply because the alternative, giving up, letting the family's version of the story stand unchallenged, was never actually a version of my life I could have lived with afterward. I want to close this out by telling you what happened to that Cavalier Hotel receipt, the very first piece of concrete evidence I ever found of Julian's affair, because I think it is a fitting small detail to end on. I kept it, the physical copy, in an evidence sleeve in the same locked drawer as everything else, through the entire trial, through the settlement, through both years that followed, and this past spring, on the 3rd anniversary of the day I first found it folded into a jacket pocket while doing ordinary laundry, an act so mundane it still strikes me as almost absurd given what it eventually uncovered. I finally took it out, along with Vivian's letter and the case file printouts I no longer needed for any legal purpose, and I burned all of it, carefully, in a small fire pit in my backyard, on a cool evening with Daniel beside me and Marisol asleep upstairs, watching 3 years of quiet, careful documentation curl into ash and understanding, watching it, that I was not destroying evidence of anything I still needed to prove. I had already proven it, in the only room that had ever actually mattered. I was simply, finally, letting it stop being the thing that defined the shape of my days. Marisol saw a child therapist for 8 months that first year, a decision my father encouraged gently but firmly, reminding me that even a 7-year-old who does not fully understand the mechanics of a custody dispute or a federal fraud investigation still absorbs, in her own way, every change in household routine, every tense phone call overheard through a closed door, every holiday that suddenly looks different than the one before it. Dr. Amara Ose, no relation to Daniel despite the coincidence of surname that made our first phone consultation slightly amusing, worked with Marisol using play therapy techniques, small figures, and a dollhouse Marisol eventually named, with the specific literalism only a 7-year-old manages, the fixing house. And Dr. Ose told me, at our final wrap-up session that spring, that Marisol had processed the entire ordeal with what she called remarkable resilience, rooted almost entirely in her absolute confidence that her mother was handling everything correctly, a confidence Dr. Ose noted was considerably rarer in children of contentious custody disputes than most parents assume, and that it reflected, in her professional opinion, a child who has internalized, correctly, that she is safe, because the adult managing the crisis around her never once let that management compromise her actual day-to-day sense of security. I do not know if I fully believed, every single day of that year, that I was handling everything correctly. I know that Marisol believed it, unwaveringly, and that her belief became, on more nights than I like to admit, the actual fuel that got me through documentation sessions I genuinely did not want to keep doing. I want to tell you about one more conversation with Agent Whitfield. From the following spring, well after the trial had concluded and the federal case against Vivian had already resulted in her guilty plea. Because it gave me a piece of context I had not previously had about exactly how close the entire scheme had come to continuing indefinitely, undetected, had Dr. Nwosu's forensic evaluation not surfaced the excise tax discrepancy that first brought his office into the case. "Commander," he told me, over coffee at a small shop near the federal building, a meeting he had specifically requested once his active role in the case concluded, no longer bound by the same procedural distance. "I want you to understand something about how these cases usually go. Most family financial fraud schemes like this one, the kind built slowly, over years, through small transfers and inflated titles rather than one dramatic theft, they almost never get caught through routine audit. They get caught because someone inside the family, usually someone the family fundamentally underestimated, finally decides to look closely enough, methodically enough, and for long enough to see the whole pattern instead of just the individual pieces. If you hadn't built that case yourself, on your own time, largely without any formal law enforcement resources behind you until very late in the process, this family would very likely still be running exactly the same scheme today, on a slightly larger scale, for however many more years it took before something else, a bank audit, an unrelated lawsuit, a family member's own falling out, eventually forced it into daylight. You didn't just protect your own daughter's financial security, Commander. You almost certainly protected every future person that family would have eventually drawn into the same pattern, had it continued unchecked. I think about Agent Whitfield's assessment often, because it reframes something I had not fully considered during the year I spent building that case, focused as I necessarily was on the immediate, personal stakes of my own custody and my own financial exposure. That patterns of entitlement and quiet financial extraction, left unchallenged, do not simply stay contained within a single marriage or a single generation. They metastasize. They find new spouses, new in-laws, new employees, new business partners, each one absorbing a portion of the family's fiction until someone, somewhere, finally refuses to keep absorbing it. I did not set out, in July of that year, to be that person for anyone beyond myself and my daughter. But I have come to understand, in the years since, watching that family's collapse ripple outward into 31 lost dealership jobs, into a bar disciplinary action, into a magistrate's quiet decision not to seek re-election, that refusing to keep absorbing someone else's fiction rarely stays as contained as you initially intend it to be, and that this, too, is a kind of consequence worth understanding before you decide whether the quiet, unglamorous work of documentation is worth the exhaustion it costs you. Ray Delgado told me, at one of our coffees last year, a story about Anthony Marchetti Sr. that I had never heard before, one from the earliest days of the original dealership. Back in 1987, when Anthony Sr. was still selling cars himself off a single gravel lot on Military Highway, with exactly 2 employees and a loan from a local credit union, he was terrified he would not be able to repay. Ray, who had known him since they were both 24 years old, working the same used car circuit before Anthony Sr. struck out on his own, said that Anthony Sr. used to keep a small, handwritten ledger, not for the business itself, which had its own formal books, but a private, personal ledger where he tracked, in his own words as Ray remembered them, every dollar anybody in this family ever needs from me and doesn't pay back, so that someday, when they ask me why I don't trust them with more, I can show them the actual math instead of just my gut feeling. Ray said Anthony Sr. showed him that ledger exactly once, sometime in the early 2000s, half joking, half serious, and that it already ran, even then, to several pages, mostly small amounts, a few $100s here and there, loaned to a cousin or a brother-in-law, and quietly never repaid. I think about that ledger now, a physical, handwritten predecessor to the encrypted case file I would eventually build against his own children and widow 20 years later, and I wonder whether Anthony Sr., watching his family from wherever he is now, if anywhere at all, might recognize something familiar and almost vindicating in the fact that it was his own daughter-in-law, the quiet Navy officer nobody in that family ever bothered to really see, who finally picked up the exact instinct he had once quietly practiced alone at a kitchen table and did something real with it. There is a specific kind of quiet that settles over a house once a fight like this one is finally fully over. And I want to describe it to you because I think it is the part of this story that television dramatizations of revenge and vindication almost never bother to include, focused as they usually are on the courtroom triumph itself rather than what comes after the adrenaline fades. For the first several weeks after the trial, I found myself waking at odd hours, 2 a.m., 4 a.m., with my heart already racing before I was even fully conscious, my body apparently still operating on the threat assessment rhythm it had maintained for nearly a year, unable, at first, to simply believe that the danger had actually passed. I started, at Daniel's gentle suggestion, seeing a therapist myself that winter. Dr. Osei's professional referral, a psychologist named Dr. Samuel Katz who specialized in what he called post-vigilance adjustment, a phrase I had never heard before, and that described, with uncomfortable precision, exactly what I was experiencing. The difficulty of standing down from a state of sustained, disciplined alertness, once the actual threat that required it, has finally, verifiably ended. Dr. Katz told me, in our second session, that this was extremely common among people who had spent extended periods managing a serious threat largely alone, without daily emotional support. A pattern he said he saw constantly in combat veterans and, somewhat less expectedly to me at the time, in people who had spent a year or more quietly managing a family's financial or emotional abuse, without anyone else fully aware of the scope of what they were carrying. It took me nearly 5 months of that work to fully believe, in my body, and not just in my legal paperwork, that I was actually safe. I share that not to undercut anything about the victory itself, which was real and which mattered, and which I would make the exact same choices to achieve again without hesitation. I share it because I think stories like this one owe their audience an honest account of the full cost, not just the satisfying resolution. And because I suspect there are people watching this right now who have already won their own version of this fight, in a courtroom or otherwise, and who still, months or years later, find themselves waking at 2 a.m. with their heart racing for reasons they cannot immediately explain. If that is you, I want you to know that is not a failure to fully recover. It is simply the body's honest accounting of what it actually carried, and it deserves the same patient, disciplined attention you gave to building your case in the first place. I want to return one more time to Brooke, because there is a final piece of her story I have not yet told you, one that reached me only this past winter, nearly 3 years after that trial, and that I think closes her particular arc in a way that feels, to me, like the truest possible ending for a woman whose defining trait had always been the ability to make manipulation sound like concern. Brooke reached out to me directly, for the first time since the trial, through a brief, carefully worded email, asking whether I would be willing to speak with her, not about the past, she specified, but about a professional matter, and curious, despite every instinct telling me I owed that family nothing further, I agreed to a single phone call. Brooke, it turned out, had spent the 2 years since her divorce building a small but increasingly respected practice specializing in whistleblower protections for financial services employees. A specialization, she told me, with what sounded like genuine, hard-won humility, she had chosen specifically because of everything she had watched happen to her own family, and to me, during that year. I used to think being smart meant knowing how to protect the people already in power, she said at one point in that call, in a voice considerably less polished than the one she had used at that coffee shop in Ghent years earlier. It took losing basically everything to understand that being actually smart means knowing how to protect the people the powerful ones are trying to quietly extract from. I'm not asking you to forgive any of it, Elena. I don't think I've earned that, and I'm not sure I ever will. I just wanted you to know that whatever else I got wrong, I did eventually learn the actual lesson, even if it took losing my marriage and my reputation to get there. I did not tell her I forgave her, because I am not certain, even now, that I do. Not fully. Not in any way that would erase what those months of quiet coordination with Douglas Ferris actually cost me. But I told her I was glad the lesson had landed somewhere useful, and I meant it. And I think that particular, complicated honesty is probably the closest thing to resolution that story will ever get. For either of us. I think, in the end, about what I would tell the version of myself sitting in that Norfolk courtroom on that November morning, unpinning a medal because a magistrate asked her to, not yet knowing that Exhibit 14 was about to change the entire shape of the day, not yet knowing about the IRS investigation that would follow, or the bar disciplinary action, or the dealership's collapse, or the 11 months Vivian would eventually spend in a federal facility learning, far too late, that her family's comfort had never actually been free. I think I would tell her exactly what I am telling all of you now, at the end of this story, The people who underestimate you, who mistake your patience for permission and your silence for stupidity, are handing you, every single time they do it, the exact advantage you need to eventually prove them catastrophically wrong. They will never see it coming, precisely because they have never had to develop the discipline to look closely at anything they assumed already belonged to them. And when the moment finally comes, the moment where all that quiet documentation, all that patient reconnaissance, all that discipline finally gets to become action, it will not look like rage. It will look exactly like what it actually is: a woman who was underestimated for the last time, calmly setting a medal down on a table, and calmly, deliberately, picking up everything else. There is one final detail I have been saving, because I think it belongs at the very end of this account rather than tucked somewhere in the middle of the legal proceedings, and it concerns Douglas Ferris, the attorney who spent months quietly coordinating custody strategy from behind his partner's marriage, while formally representing no one in that proceeding at all. Ferris's 18-month bar probation ended last spring, and rather than returning to family law, he left Ashworth Kellerman Pruitt entirely, resurfacing, according to a professional networking update a former colleague of Priya's happened to notice, as a strategic consultant for a small firm specializing in reputation management. A career pivot that struck both Priya and me, when she told me about it over coffee, as almost darkly funny, a man whose entire professional collapse had been caused by his own inability to manage the reputational fallout of his own conduct, now advising other people on exactly that skill. Priya, who has seen more lawyers reinvent themselves after professional disgrace than she probably cares to count, told me she gives Ferris roughly even odds of building something genuinely sustainable out of that pivot, and roughly even odds of finding some new, quieter way to eventually repeat the exact same mistake. Because, in her words, some people learn from consequences, Elena, and some people just get better at avoiding the specific kind of consequence that already caught them once. It usually takes watching someone for another 5 or 10 years to know which kind you're actually dealing with. I think that observation, more than almost anything else anyone said to me across that entire ordeal, captures something essential about how I have chosen to think about consequences in the years since. Not as a single dramatic reckoning that permanently and completely transforms a person's character, but as an ongoing, unfinished question that only time and continued observation can actually answer. Vivian may never fully absorb the lesson her federal sentence was supposed to teach her. Her letter, alternating as it did between genuine remorse and reflexive entitlement, suggests the jury on that question, so to speak, is still very much out. Chase may have found in his more modest apartment and his more modest, more honestly earned paycheck a genuine and lasting humility. Or he may simply be waiting, quietly, for some future opportunity to rebuild the same comfortable extraction on a smaller, more careful scale. Julian, 11 consecutive months of reliable visitation and counting, may be building the foundation of an actually trustworthy fatherhood, or he may simply be performing accountability the same way he once performed wealth, until the audience watching him stops paying such close attention. I do not know, with certainty, which of these outcomes will prove true for any of them, and I have made a deliberate choice, in the years since that trial, not to need that certainty in order to move forward with my own life. My job was never to guarantee their redemption or their continued failure. My job was to protect my daughter, to reclaim what had been taken from me without my knowledge or consent, and to build, afterward, a life honest enough that I would never again need a private journal and a locked drawer to keep track of who I actually could and could not trust at my own table. I want to tell you before I close this out about the smallest, quietest moment from that entire year, the one that has stayed with me longer and more vividly than almost any of the courtroom drama, because I think it is the moment that actually taught me the most about what I was building and why it mattered. It was a Tuesday evening in September, roughly 2 months before the trial, and I was sitting at the kitchen table with my laptop open to a spreadsheet cross-referencing dealership payroll records, a task I had by then repeated so many times the numbers had started to blur together into something almost meditative, when Marisol wandered downstairs in her pajamas, unable to sleep, and climbed into the chair beside me without asking what I was doing, the way young children often accept a parent's work as simply an unquestioned feature of the household landscape. She sat there for a while, quietly drawing on a spare piece of printer paper, and then, without looking up, she asked, "Mommy, are you counting the bad numbers again?" I asked her what she meant by bad numbers, genuinely curious how a 6-year-old had apparently developed her own private taxonomy for what I was doing every night at that table, and she said, matter-of-factly, still drawing, "the numbers that don't add up right." You always look extra serious when you're counting those." I remember laughing, quietly, surprised at how precisely she had described forensic accounting without any of the vocabulary for it. And I told her, "Yes, baby, I'm counting the bad numbers, and someday soon they're going to add up to something that fixes everything." She nodded, entirely satisfied with that answer, the way children are satisfied with answers adults spend years earning the right to give with any real confidence, and went back to her drawing, and I went back to my spreadsheet, and I remember thinking, in that specific, ordinary moment, that whatever else that year cost me, it had also given my daughter a front row seat, however unconsciously absorbed, to watching her mother refuse to look away from something difficult, simply because looking away would have been easier. That is, in the end, the thing I most want this story to leave you with. More than the satisfaction of Vivian's shaking hands at her sentencing. More than Brooke's grin finally disappearing in a Norfolk courtroom. More than the particular, specific pleasure of pinning a Navy cross back onto my own uniform, in full view of reporters who did not yet understand what they were watching. The bad numbers rarely fix themselves. They require someone patient enough, disciplined enough, and quietly furious enough to keep counting them, night after night, long after everyone around her has stopped noticing anything is wrong, until the total finally, undeniably, adds up to the truth. I was that person, for my daughter, for myself, and eventually, whether they intended it or not, for every future person that family's fiction would have otherwise continued to quietly consume. And if there is a single lesson underneath every single detail of everything I have told you today, it is simply this: never let anyone convince you that your careful, quiet attention to the truth is anything other than exactly the kind of strength it actually is. I have thought, many times over these past 3 years, about what separates a family like the one I married into from a family that actually deserves the loyalty it demands, and I keep arriving at the same answer. One simple enough to state plainly, even though living it out took me the better part of a decade to fully understand. A family that deserves your loyalty never needs you to stay silent to keep functioning. Every single dynamic I have described to you today, Vivian's entitlement, Chase's laziness, Brooke's opportunism, Julian's quiet, practiced dishonesty, depended structurally on my continued silence, on my willingness to keep smiling at Sunday dinners, to keep signing documents without asking too many questions, to keep absorbing financial exposure without demanding a full accounting of where the money was actually going. The moment I stopped being silent, the entire structure collapsed within a matter of months, not because I was uniquely powerful or uniquely vindictive, but because structures built on someone else's silence are, by definition, never actually stable. They only ever look stable, for as long as the person being asked to stay quiet keeps agreeing to. I think about the version of me who married Julian on that pier in Cape Charles, 29 years old, watching the sun go down behind a man I genuinely believed loved me as completely as I loved him, and I do not regret her choice. Even now, even knowing everything I know. She could not have known what she was walking into, not with the information available to her at the time, and I refuse to spend any more of my life being angry at a younger version of myself for trusting a story that an entire family had spent decades perfecting. What I can do, what I have chosen to do, every single day since that courtroom in Norfolk, is make sure that the woman I am now, the one who learned exactly what silence costs and exactly what documentation can protect, never again mistakes a family's performance of love for the actual, verifiable substance of it. I built a new table, in a new house, under a name that belongs entirely to me, surrounded by people whose care for me has never once required my silence to sustain itself. And every single night I sit down at that table, I understand, more clearly than any courtroom verdict could ever teach me, exactly what the entire fight had actually been for. Marisol is 9 now, and she still, occasionally, asks me about the bad numbers, a phrase that has become something of a private joke between us, a shorthand for any situation, large or small, that requires patient, careful attention before it can be trusted. Last month, helping her with a school project about family history, she asked me, with the same matter-of-fact curiosity she'd had at 6, whether I thought Grandma Vivian would ever understand what she did wrong. I told her the truth, the same truth I have tried to give you across this entire story, that some people learn from consequences, and some people simply get better at avoiding the specific kind of consequence that already caught them, and that the only thing either of us could actually control was making sure we never again let anyone's performance convince us to stop trusting our own eyes. She thought about that for a long moment, in the serious, careful way she thinks about most things now, and then she said, I think that's why you're the toughest person I know, Mommy. You always trust your own eyes, even when everyone else is telling you not to. I do not know if I have ever received a better piece of praise in my entire life. From a courtroom, from a promotion board, from anyone. I want to leave you with one last image before I close this out, because I think it says more than any summary I could offer. 2 winters ago, on the anniversary of the trial, I drove past the old Norfolk dealership location, the one now converted into a self-storage facility. The one where Anthony Marchetti Sr. once sold cars off a gravel lot with 2 employees and a loan he was terrified he couldn't repay. And I sat in my car for a few minutes in the parking lot, watching a light snow start to fall over rows of orange roll-up doors where a family's entire performed empire used to stand. I thought about Vivian's cream jacket, about Brooke's grin in that second row, about Chase's feet up on a coffee table, about Julian's face going the color of old paper when Priya said the words Exhibit 14. I thought about my father's steady hands, about Priya's legal pad covered in strategy, about Dr. Nwosu's laser pointer tracing $48,000 across an exhibit board, about Agent Whitfield's quiet, methodical confirmation that federal authorities had finally started paying attention. I thought about Marisol, asleep in her own bed that night, safe, secure, and completely unaware of how close an entire family's careless, entitled fiction had once come to costing her everything that actually mattered. And I thought, finally, about the exact moment I unpinned a Navy Cross from my own uniform because a magistrate told me to, and set it down on a table without argument, understanding even then, in the coldest, most disciplined part of myself, that I was not giving anything up. I was simply choosing, with total precision, exactly which battle was worth winning, and exactly how completely I intended to win it. I put the car back in drive after a few minutes, snow gathering lightly on the windshield, and drove home, to a table that belonged entirely to me, to a daughter who trusted her own eyes because she had watched her mother trust hers first, to a life built, finally, on numbers that added up honestly every single time I checked them. There is a particular kind of confidence that only arrives after you have survived proving, methodically and completely, that you were right about something everyone around you spent years insisting you were imagining, and I want to describe it to you honestly, because I think it is different from the confidence people usually mean when they talk about coming out stronger on the other side of a hard year. It is not loud, it does not announce itself, it does not require ever again raising your voice in a room to be taken seriously, because you have already learned, in the most concrete way possible, that the quiet, patient accumulation of verified fact will always eventually outweigh anyone else's performance, however polished, however loudly delivered, however many generations of practiced entitlement stand behind it. I carry that confidence now into every part of my life, into my work at Treasury, into my relationship with Daniel, into the way I parent Marisol, into the small, ordinary decisions of an average Tuesday, and I think it is, ultimately, the single most valuable thing that entire ordeal left me with, more valuable even than the financial restitution, more valuable than the professional consequences that eventually landed on every person who spent 6 years quietly underestimating me. I think, too, about all the women who have written to me since this channel started sharing pieces of this story, women navigating their own versions of a family that mistakes patience for permission, a spouse who performs a life they cannot actually afford, a courtroom that does not yet fully understand the difference between military service and instability. I do not have a universal formula for what any of you should do, because every situation carries its own specific facts, its own specific risks, its own specific timeline for when documentation becomes safe to act on, and when it still needs to stay quietly building in the dark. But I can tell you, with total certainty, born from the single hardest year of my adult life, that the instinct telling you something does not add up is almost never wrong. That the discipline to keep looking closely, even when everyone around you insists you are imagining things, is not paranoia, it is preparation. And that the version of you who finally stops absorbing someone else's fiction, whenever that day arrives for you, will look back on the version of you who spent months quietly building a case file at a kitchen table with nothing but respect for exactly how much strength that patience actually required. Vivian is out of federal custody now, living in a small apartment in Chesapeake, according to the last update Ray Delgado gave me. Still, as far as anyone can tell, insisting to whatever friends remain willing to listen that the entire ordeal was fundamentally unfair, a misunderstanding blown wildly out of proportion by an overzealous prosecutor. Language that tells me, more clearly than any formal psychological evaluation could, exactly how much of the actual lesson she has genuinely absorbed. I do not need her to absorb it. I do not need any of them to fully understand, in the end, exactly what they cost me, or exactly what they lost in the process of trying to take it. I only ever needed the truth to be documented, verified, and finally, undeniably placed on the record, in a room with the authority to make it matter. Everything after that, every individual consequence that eventually landed on every individual person in that family, was simply the natural, inevitable weight of gravity finally catching up to a story that had been floating, unearned and unexamined, for far too many years. I still wear the Navy Cross to every formal occasion that calls for dress blues, and I still, every single time I pin it on, think for just a moment about that Norfolk courtroom, about a magistrate's request I answered without argument, about a sister-in-law's grin that meant nothing by the time the day was over. It is not a wound anymore, that memory. It is closer to a kind of quiet proof, carried on my own uniform, of exactly what I am capable of protecting, and exactly how completely I am capable of protecting it, once someone finally, foolishly, gives me a reason to prove it. I think Anthony Marchetti Sr., watching from wherever fathers watch the collapse of everything they once built, might have understood that particular kind of proof better than anyone else in his family ever did. I think he would have respected it, even aimed as it eventually was at people who carried his own name. There is a version of this story where I tell you it ended the day that federal grand jury handed down its indictment, or the day Vivian's sentence was read, or the day I pinned that new commander's insignia onto my own shoulder boards with my father's steady hands guiding mine. But the truth is quieter than any single ending and considerably less cinematic. It ends every ordinary Tuesday I sit down at my own table, in my own house, under my own name, and watch my daughter draw pictures of a mother she describes to anyone who asks as a secret spy who catches bad guys with numbers. And I understand, watching her, that the actual victory was never the courtroom at all. It was simply this: an honest table, a daughter who trusts her own eyes, a silence, finally, that belongs to me, instead of one I was ever again required to keep for anyone else. But that quiet, honest table almost didn't survive the spring after the trial, because that was exactly when Preston Kellerman, freshly separated and apparently desperate to salvage what remained of his own reputation at the firm, made one final, reckless move that nobody, not even Priya, saw coming. A move involving a sealed file from Douglas Ferris's own archives that he was never supposed to still have access to, and the first person he decided to send it to wasn't a judge, or a reporter, or the state bar. It was me. And what was inside that file changed everything I thought I already knew about who had actually been coordinating this family's cover-up from the very beginning. If you've ever had someone hand you the one piece of evidence that rewrites a story you thought was already finished, comment the file below, because that's exactly where the next video picks up. And if this story earned it, you already know what to do before you go.